Who is appearing for the food and civil supply?
Then civil supply, probably government and government.
What is your stand? You are not aware of it.
Actually, my lord, these matters are handled by some other council. And lordship, I believe 5 minutes time, my lord.
We'll take it up after some time.
My lord.
Item number 2.
Nobody from the government?
Senior is on legs for time being.
Who?
Senior,
Who is that?
item 2. Actually,
Where is it?
is over court 1.
Take it up after some time. If it is not there, we'll ask the appropriate orders. And madam, ask your government people to appear in these matters because this is not a matter you are going to appear. I don't think so. This is a challenge made to a recruitment made of the police. Ask your people who appears out here.
Item 3.
Yes, Mr. Roy.
Not the challenge made in this non-selection of the petitioner will not to the post of administrative officer scale 1. My lord will kindly come to the there is a procedure, my lord.
No, Mr. Roy, what are you asking for?
My lord,
Why the select
no, my lord,
stated so and so published and consequential appointment of selected candidates should not be quashed.
my lord, I will not pray for that now. I will not pray for that. I'll just because I have a limited prayer now because I am retired. Therefore, my lord, if my prayer is limited, lordship kindly see the manner in which the thing everything was done. Lordship will kindly see there is a procedure laid down, my lord. Lordship perhaps has seen, my lord, seniority mark, interview mark, and my lord walks mark, qualification marks are fixed. The petitioner, my lord, based on his seniority and qualification, he was placed in a higher position. Item serial number 12 or something. But after final selection, they found the person who was at serial number 101 with much lesser mark has been selected. So, my lord, my friend, because they said that I specifically said that I have no adverse remarks in this. Never. They said no. So, if that be so, then definitely, my lord, they have considered my uncommunicated adverse remark. This is number 1. Thirdly, when they replied, they did not say, they only said the seniority, qualification, and works based on works experience. I was found, did not say anything about interview.
Understood, but Mr. Roy, what can be done in this petition? What you are asking cannot be undone now.
No, I'm not. I'm only saying that let them show me the result. That is what my prayer was. They said, no, we cannot show it. What marks I got in interview on work experience, let them show it to me. If I find that it's okay, it's okay. This is
Who is paying for government? For the insurance?
for the national interest.
Yes. You see, otherwise the petition has become infructuous because he has already retired. He wants to only see the mark.
That's
Do it to him.
marks of the interview. Marks of the interview.
Mark of the interview.
Relative candidates, but not me only. Relative candidates. That I'll be satisfied. At least
So that you have not filed your reply also? Have you filed
We
your
have
reply?
filed.
They filed.
We have
Well-
filed, and we have also stated that he was subsequently promoted in the next
That's true, you know, but then
promotional exercise.
if I get the promotion from that date, I'll get some financial benefit. That's all.
In
But what
addition-
are you going to do now?
No,
If
I'll
you
not,
get the marks also?
my lord, if the marks are out, they'll make a review of it, my lord. Because they cannot really, because there's one case division bench, one division found that a candidate has been given, I have annexed that, my lord, a higher mark. My lord, additional mark. The division bench says this cannot be done. But this is the practice they follow, my lord. They do it. That's why my apprehension is that let them show it to me why they are shying out my lord, to show that.
So you want that on the marks, the comparative marks with the other candidate
sir.
be furnished to you
Yes, sir. All
for that particular select list?
that's right.
Heard Mr. P.K. Roy, the learned senior counsel, assisted by, and Mr. B.J. Mukherjee appears on behalf of the National
Insurance company.
Company Limited. The instant writ petition was filed challenging a select list dated 30/9/2010, published by the respondent number 1, and the consequential appointment so made to the selected candidate, as well as also for a direction to convene a review DPC for the selection of eligible candidates to the cadre of administrative officer, bracket scale 1, under para 13.1, under para 13.1-2010. It transpires from the records that the petitioner, at the time of filing the writ petition on 8th of April 2011, was 49 years. The learned counsel appearing on behalf of the senior counsel appearing on behalf of the petitioner submits that in the meantime the petitioner was in the meantime the petitioner have also been given promotion and had also retired. He, however, submits that the respondent authorities, more particularly the respondent number 1, be directed to provide the comparative marks obtained by the selected candidates vis-a-vis the petitioner, so that the petitioner, if necessary, could seek appropriate remedies as available. Mr. B.J. Mukherjee, the learned counsel appearing on behalf of the respondent National Insurance Company Limited or what?
Lordship.
National Insurance Company Limited, submits that the respondents have no objection in providing the the marks obtained by the selected candidates with, as well as the marks obtained by the petitioner, on the basis of which the select list dated 30/9/2020 was published. Taking into account the above, the instant writ petition therefore stands disposed of, with a direction upon the respondent number 1 to provide the petitioner the marks obtained by the selected candidates as well as the marks obtained by the petitioner. Selected candidates who were selected by the select list dated 30/9/2010, as well as the marks of the petitioner in respect to the said selection proceedings. With the above, the petition stands. Yes, who is appearing for item number 1?
Timing item 1.
Lord, I have been told, my lord, the relief sought for in the present expedition, my lord, has been provided to the petitioner.
It has become infructuous. Your name is?
My lord, M.U. Mondo.
M.U. Mondal, the learned counsel appearing on behalf of the petitioner, who submits that the relief which was sought for by the petitioner have already been granted to the petitioner, and as such, the petitioner would not like to press the instant petition. In that view of the matter, the instant with petition stands closed.
Applause.
Yes, Mr. Gustami, you are appearing for item number 2.
Yes, Lordship, but I have no brief, Lordship. Second file is required.
Take it.
Item 2.
Second file. 2011 method.
This was a matter pertaining to selection of the SI.
Yes.
Only one thing which this court would like to know. You see the affidavit which was filed. Prior to that, if I may take you to the advertisement. Kindly come to advertisement at page number, annexure 3, page 34. Of the petition.
Four, Lordship.
This was an advertisement pertaining to 98 posts, of which 27 posts were reserved for OBC and MOBC.
Lordship.
Okay.
Lordship.
From a perusal of this, it does not reflect that there is any reservation for ladies. Except what has been mentioned in clause number 9.
In respect to the women candidates, admissibly relaxation of the physical measurements and physical test will be given. The candidate will have to appear in all the list of their own expenses. The candidate.
Okay.
Yes.
Now, what has happened out here, you take the affidavit which has been filed. The petitioners herein were duly selected for other written examination pass. Then they also passed the PET. The only question is as regards the personal interview.
Lordship.
Now, in your affidavit, you have also stated how the marks were given.
Yes, Lordship.
If you see page
Page
number 3,
3, yes.
as to how the marks have been given, educational qualification 10
Graduation,
marks,
5.
NCC 5 marks, computer and other activities 5 marks, and Viva Voce 30 marks.
Lordship.
Now those who had graduate, you have given 5 marks,
5 marks.
postgraduate 6
6
marks, and bonus 1 mark for first division. Now the petitioners in this case have only passed simple graduation.
Lordship.
So you have given them 5 marks.
5 marks.
Now, if you see the select list is the one which is being passed out here at annexure C,
Annexure
page 19.
Yes.
And running page 62.
Lordship. Annexure C.
A total of 132 candidates were listed out.
132. Lordship.
Of these 132, the petitioner number 1 falls at serial number 114,
Yes. 114, Lordship.
and the petitioner number 2 or petitioner number 1 falls at 118, and the petitioner number 2 falls at 114.
Yes.
And these are OBC candidates, and they have got 199.5 and 197.5. Okay.
Yes.
Now you see another aspect. The number 115 is Miss Midula Kuar.
100.
You see the name
Yes.
115. Our number is also 199.5.
Yes. Lordship.
Okay.
Yes.
Then there is another person whose name is out here. If you find out there, that another lady, this Miss Annapurna Chetri. You get it? 126.
126. Get it. I got it.
She has got 191.5.
OBC. Yes.
Okay.
Yes. Sir.
Now, if you see here, the general unreserved list, Annexure D, we are not concerned with that. STP, not concerned. Finally come to page 27, OBC, MOBC merit list.
Yes. OBC, MOBC merit list.
Now, if you have seen the petitioner herein, the petitioner number 2 got
Medulla core.
Sumon
Sumon,
Gogoi
yes.
got 199.5,
Yes.
and Konokeshwar Sinha, who is the petitioner number 1, got 197.5 at page 21.
Yes. Page
Okay.
21. Suman Sinha.
Sumon Sinha,
Sujan Sinha.
Sumon Gogoi
Yes.
got 199.5. Page 21,
Yes. I got it.
serial number 114,
Yes.
and serial
114.
number 118. Another person, that is the petitioner number 1, got 197.5.
Yes.
Okay.
Yes.
Now kindly come to page 27.
27.
From the
Of this-
last 2 persons, Midula Gogoi
Medulla core, Lordship.
who got 199.5.
5. Yeah.
That is the same marks which the petitioner number 2 has got.
Yes. Lordship.
Okay.
Yes.
Now petitioner number, then Miss Annapurna Chetri got 191.5 OBC. Okay,
Yes.
she got it out there. However, the petitioners who were there, 199
Nine.
and 197, did not get. Was it because of some reservation being given? Then you see another aspect. There's an affidavit in reply filed.
The petitioner. Yes.
The affidavit in reply says about another very important aspect to the matter. About the other things I am not concerned. Kindly come to paragraph number 11.
Got it, Lordship. 11.
In this OBC category, there were 4 persons who did not accept.
OBC category, namely Sujan Sinha, Prabir Rajkumar, Pratim Jyoti Datta, Himanshu Jyoti Bora, of their unwillingness to join in the said appointment for disclosure by the RTI application. RTI application dated 17/10/2021.
Yeah. And as such, the 4 number of posts of OBC category, 3 numbers of STP, 1 number of ST, and 3 numbers of general category of SY out of 98 were lying vacant. Then, if they didn't join, would the petitioners not be entitled to, taking into account that there were 132 candidates?
Might be. But now the thing is that it is all the processes in 2011.
Understood.
Now it is 2023, Lordship. It is the defense force, Lordship. Is the defense force, Lordship. And the other aspects is required, Lordship, the physical. Now, what is the issues, the trainings, all these things,
No. There is no reply from there
Lordship.
thereafter.
Yes.
Because this was filed as far back as in, this affidavit was filed as far back as on
It is
6th of December 2018.
yes.
So what remains in this proceeding?
Now 2018.
So
After that,
till
nothing.
2018,
Yes.
I think the petitioners have not been taken into account.
Yes.
Otherwise, why would they file this?
Yes. till 2018, it means 4 posts vacated at that time. But it is from the reply, it is not specific that although they are not joined, 4 persons were not joined at that time, Lordship, during the process of this advertisement, Lordship. But after that, what happened in this type of force cases, Lordship, when the vacancy raised, Lordship, if the new enrollment, new advertisements comes after that, so many advertisement comes, it may be filled up later on. Till 2018, it is vacant. But now, Lordship, so many new enrollment process has done, Lordship. Otherwise, they have a case, Lordship. But the issue is that now, at this present stage, Lordship, 2011 advertisement, Lordship, now it is 2023.
You take your instructions by Friday.
Yes, Lordship.
And
Regarding,
as to what has happened to those folks,
yes, Lordship.
none appears on behalf of the petitioner on call. Mr. J.K. Goswami appears on behalf of the respondent state. The instant writ petition was filed by the petitioner challenging their non-selection pursuant to the advertisement dated dated 1st of January 2010 in respect to the recruitment of sub-inspectors in Assam Police 2010. It appears from the said advertisement that there were 98 vacancies, of which 27 vacancies were reserved for OBC/MOBC. The petitioners herein claim to be claim to be entitled to the reservation in the OBC category. It further reveals from the records more particularly the affidavit in opposition filed by the respondent number 1, by respondent number 4, that the petitioners did not feature in the OBC/MOBC merit list. Be it as it may, from a perusal of the affidavit in reply, more particularly at paragraph number 11, it was disclosed by an RTI reply dated 17/10/2011 that 4 of the candidates who were in the merit list of the OBC in the OBC category did not join. For which the said 4 posts reserved for OBC candidates were vacant, remain vacant. This court directs Mr. J.K. Goswami, the learned counsel appearing on behalf of the respondent state, to obtain necessary instruction as to what the respondent authorities have done in respect to those posts, as well as also obtain instruction as regards the veracity of the statements made in paragraph number 11 of the said affidavit in reply. That the matter again be listed on 23rd of July, June.
May I take copy of this?
You don't have it?
This is 2011, Lordship, in my office.
We will give you a copy.
Thank you, Lordship.
Item number 4.
Yes.
Lord, this petition has been preferred against the imposition of penalty under Assam Cooperative Apex Bank Limited Staff Rule.
Matter pertains to?
My Lord,
What are you asking for?
I am asking for the passing of the penalty, my Lord, penalty order that was imposed by the managing director, who was not the enquiry officer. Enquiry was held by some other person, and
The inquiry was in your favor,
enquiry is in my favor, but even
but
then,
they have they said that nothing doing, one increment,
yes,
imposition.
one increment, and the period of leave shall be deemed as unauthorized without salary, my lord.
No, it has
No,
been, no. Madam, kindly come to page 43.
Yes, page 43, that
His period of leave, absence
Yes,
from
yes,
so-and-so
my
to so-and-so may be treated as extraordinary leave without salary.
yes, annual increment or withholding of one annual increment, and his period of absence from 8407 to 41007 may be treated as extraordinary leave without salary. That is the penalty. And I was not given the enquiry report, although I am entitled to that. Violation of natural justice.
Why? Why violation of natural justice?
Because I was not provided with
No. Is the order passed on the basis of the inquiry report?
No, inquiry report was not considered because inquiry report was,
Inquiry report was considered, inquiry report was in your favor.
yes.
So where is the question of giving you the inquiry report?
Even then, my lord, I could have made representation, although after 42nd amendment, the second so-called
Now tell me
notice
whether prior to this, a notice was issued to you.
notice of imposition of penalty. No, my lord, nothing.
Yes, Mr. Gustami. Kindly come to page 42.
Lordship, I have my Lordship. This record was received by me, Lordship, today itself. At the same time, Lordship.
Give it to me. I will be much faster
Yes,
to find out if there is anything. If the record is given.
Yes. Earlier, the direction to produce report. Kita connect. No, you connect. Ini satu forward lagi.
It's
Yes, why didn't you give the copy of the inquiry report in spite of the opinion being in his for giving the report? See the file?
The inquiry report, Lordship, although the inquiry officer could not establish any of the three charges, Lordship, but at the same time, Lordship, so far the medical board uh, could not agree with the certificate issued by the specific doctor, which is produced by the petitioner, Lordship. Connecting on the basis of that, Lordship, this the opinion was built up by the board, Lordship. Regarding the non-furnishing, Lordship, I have to take further instruction, Lordship. Record is not.
Record is there.
Yes, Lordship, record is there, Lordship, but in records, I am not able to found whether that it was furnished to the petitioner.
I'm not concerned. There is an opinion given by your counsel. The PN Gustami, I think, was the counsel then.
Yeah,
He has given an opinion that you should give it.
today itself, I got this record, Lordship, from learned senior chambers, Lord. And therefore, I'm not gone through the entire
See the
record.
office note out there, the notes out there, after the inquiry, it is written in a diagonal manner. I think just before it, wherein it says on the basis of which this order was prepared, saying that we close the particular area, DP, and impose the
So it's a
penalty of
penalty.
1 increment.
The minimum penalty.
1 increment is minor.
Is the uh, as per rule 46A, Lordship, the second category of punishment after warning, Lordship. Warning is the first category of punishment. Second is the withholding or withholding or of increment, Lordship. The second category of punishment. First one is the warning. After that is
What about, madam, about your extraordinary leave without sale? Was the leave given to you?
Leave.
Was the
earlier
leave sanctioned?
only for 3 months, sanction was made. And thereafter, as the disease was lingering, my lord, I prayed for leave for another 3 months. That instead of granting my leave, my lord, I was summoned by the medical board. I appeared and I took all the relevant papers and I was directed to go for a pathological test also. That report also was carried by me. But the medical board, without examining me, whether I was suffering from pulmonary tuberculosis, there is no such finding, that they are not agreeable to the certificates issued by my consultant physician, who is a TB specialist. And on that ground, the medical board submitted the report to give the
No, but
information.
was your leave sanctioned?
Leave was sanctioned for 3 months.
No,
only.
was the leave sanctioned from 8/4/2007 to 4/10/2007?
No leave was sanctioned.
If the leave is not a matter of right, that goes. And as regards the other one, where are you entitled to the inquiry report?
Well, 72, rule 72, for lingering disease like cancer, TB and leprosy, the 1.5 year, that is 18 months, leave is statutory, my lord. That leave was not granted to me. I am entitled to
it
that.
is
Under rule
72 is not like that, Lordship. 72 is that, Lordship. The bank may grant in a special case, not in every case, medical leave to an employee who has completed 1 year of service up to 18 months during the period of entire service of an employee on average to pay the treatment of lingering disease such like TB, cancer, leprosy, and her transparent like this 1 year for both kidneys arising out of the rental failed in addition to all other leave due to an employee on the basis of the certificate given by the appropriate medical authority, not any medical doctor. Now, the certificate which is issued by Dr. Talukdar is not deferred by the board. Lord.
Now, what is your grievance as regards one increment being stopped?
Yes.
Why?
It is stigmatic, my lord, and it is stigmatic and financial also suffered a loss, my lord. And it is stigmatic because after all punishment is punishment. It
But
may be, my lord.
why can't they give you a punishment? Your basic stand out there before the authorities is you did not know that the law stipulated that you had to give a certificate from the medical board. This aspect, the inquiry officer said, yes, truly, he may not know it. But the reason why the disciplinary authority took action against you is you can't say that you don't know the law.
No, that is the finding of the managing director, the disciplinary authority. But in my so-called, I have stated that had I been given another opportunity, because why the original certificates could not be submitted by me, because I have categorically stated while applying for leave.
No, not the original certificate. You should have place the certificate from the medical board. That was not given by you. You gave some other certificate, which is not a certificate as per requirement.
No, I was under the treatment of a private practitioner.
Whatever may be, you see, Rule 72 categorically mentions that the certificate has to be from this particular board, appropriate medical authority. Then,
But it is,
which you say that you did not know that whether he would be the appropriate medical authority or not. And the inquiry officer came to a finding, yes, he may not know about it. And as such, the charge is not established.
my lord, what prevented the authority to give me another chance to, because the relevant documents
No,
by the letter I was directed.
madam, the question of another chance or not, that is not a question before this court. The question is as to whether exercise of power under 226 should be made in this order of one increment, and as also that the period of service on so and so shall be treated, may be treated as extraordinary leave without salary.
No, my lord.
Why should this court interfere?
No, why I have come before this honorable court? Because I am entitled to get the copy of the inquiry report. Maybe because honorable Supreme Court has held in the judgment report in 1993 for SCC 727. Whenever, whatever the nature of punishment, further, whenever the rules require an inquiry to be held for inflicting the punishment in question, the delinquent employee should have the benefit of the report of the inquiry officer before the disciplinary authority records its finding on the charges leveled against him. And moreover, my lord, whenever therefore the service rules contemplate an inquiry before a punishment is awarded, and when the inquiry officer is not the disciplinary authority, the delinquent employee will have the right to receive the inquiry officer's report, notwithstanding nature of the punishment. And besides that, my lord, he may also persuade the disciplinary authority that the finding is based on of no evidence or the relevant material evidence was not considered or overlooked by the inquiry officer in coming to the conclusion, with a view to persuade the disciplinary authority to disagree with the inquiry officer and to consider his innocence of the charge. In this case, my lord, my punishment is totally on the basis of medical board's report. Medical board's report.
Madam, that judgment is pursuant to that ECI judgment.
True, my lord.
That judgment is on this aspect. Article 311(2)
Yes.
was amended. Earlier, prior to issuance of penalty, there was a necessity of issuing a notice. That has been taken away.
Yes.
That is no longer there,
No, no second suppose.
not necessary. Then matter came up before the Constitution bench in ECI and said, and the Constitution bench said that look here, the necessity to give the inquiry report, if it is against you, is for the purpose of showing, so that you can show to the authority that you don't trust this inquiry report which is made against me, because these are the faults which are there. This is not against the penalties to be imposed. If you see the ECI judgment. And as such, if the inquiry report is in your favor, the question of giving you the inquiry report does not arise.
True, my lord, but inquiry report, the managing director was not satisfied on the ground that the inquiry officer has come to a finding.
In your
that
favor.
he is- No, maybe in my favor, but it results in punishment, my lord.
No.
No, because,
Inquiry report says that you are, all the three charges
Yes.
are not proved.
but in spite of that, I was penalized, my lord.
So,
but
the
only-
moment I say that prior to that a notice has to be given, that will be violating the Article 311 too.
But one thing, my lord, that is it not prejudicial, because am I not entitled to get this inquiry report? Is it
You want the inquiry
prejudicial,
report?
my lord?
Favor.
Yes, inquiry
Inquiry
report,
report
am
is
I not
in her
entitled to that?
favor.
Anyways, you want an inquiry report?
Yes, my lord,
I dismiss your petition and give you the inquiry report.
Yes,
You
I
will
will.
give it to you, no problem. You want the inquiry report, you
No,
can
no,
keep it
that-
everywhere.
that the conduct, your lordship will be pleased to,
Madam,
take
you,
into
if you
consideration, my
want
lord.
all these things, you should have filed an appeal. I'm not going to be concerned with all these things. Their authorities have decided this aspect to the matter. You show me that there cannot be an order be passed by the disciplinary authority which goes against the inquiry. Do you have any judgments on that?
Yes.
no, it has not
We
gone
have-
against me, no doubt.
There have so many judgments that.
I know that.
Yes.
But medical board, the entire,
Why will this court look into those evidence, taking into account as to whether that evidence is right or wrong, if you have not filed an appeal? This court is sitting
that
under
is not my prayer, my
226.
lord. That is not my prayer. I have come before this honorable court because the national justice was violated because I was not given the copy. And secondly,
You
my
want the
lord,
inquiry report?
yes, my
We will
lord.
give you.
Yes.
No, no, but at this
Wait.
stage, my lord, what benefit I will,
That is what I'm saying. The inquiry report would not help you out.
that even then the finding that ignorance of law is no excuse. That is the basis. And the entire finding is based on the medical board's standing counsel's report. That is the thing. Only thing that relevant papers were not submitted, might be. But relevant papers I carried, my lord, but only photocopies, because those were with the bank. The medical board could have requisitioned those papers, because to give justice, my lord, I was suffering from a disease, and for that I underwent.
Madam, at
treatment.
best, I can do one thing. Otherwise, I'm not going to touch this. I can do one thing, ask them, dispose it off with this, and asking you to file an appeal before the authority. That you can do, at best, nothing more than that.
Lords,
Keeping the point of limitation, limit, I
Ah,
will.
the pendency of this petition during this period, if you file within 30 days.
yes.
Okay. Heard Mrs. B. Chaudhary, the learned counsel, appearing on behalf of you are still working?
Yes, but I am retiring in 2028.
Oh, your time. You can fight it. Heard Miss Each other is the learned counsel appearing on behalf of the petition. Mr. J.K. Goswami appears on behalf of the Assam Apex. What
Assam Apex Bank Limited.
is the name
All
of
the
the bank?
responded. Lordship, the Assam Cooperative Apex Bank Limited.
Assam Cooperative Apex Bank Limited. The respondent number
One and two. The
1
managing director.
and 2. Respondent number 1 and 2. The instant writ petition has been filed challenging the order dated 23/8/2010, passed by the managing director of the respondent number 1 bank, whereby in exercise of the power conferred under Rule 46 small a small Roman 2 with the bracket of the, what is this act?
Assam Cooperative Apex Bank Limited Staff Rules 1980 as amended.
As amended 1988, have imposed the punishment to stop 1 annual increment without cumulative effect, and have also observed that the period of absence from 8/4/2007 to 4/10/2007 may be treated as extraordinary leave without salary. Upon hearing the learned counsels for the parties, it transpired that the case of the petitioner, as strenuously argued by the learned counsels for the petitioner, is that the petitioner was not afforded the inquiry report, which has gone in favor of the petitioner, and the respondent number 2 had, without proper application of mind, have passed the impugned order dated 23/8/2010. On the other hand, Mr. J.K. Goswami, the learned counsel appearing on behalf of the respondent number 1 and 2, submits that when the inquiry report, that when the order impugned is not based upon the inquiry report, the question of handing over the copy of the inquiry report to the petitioner does not arise. He further submitted that the question of issuance of notice prior to imposition of penalty would be foreign, would be contrary to Article 311(2) of the Constitution, inasmuch as after the, which amendment? 44th?
42nd minute. 42nd.
Huh?
42nd.
After the 42nd Amendment of the Constitution, there is no further requirement of issuance of any notice prior to imposition of penalty. Upon hearing the learned counsels for the parties and taking into account the submission made by Ms. B. Chaudhary, the learned counsel for the petitioner, to the effect that this particular, that the certificate issued by the doctor who was under whom the petitioner was under treatment should have been taken into consideration. And the medical report and the medical board, or for that matter, the medical board's report should have been called for by the respondent authorities. This court is of the opinion that the same would be related, same would be that for this court is of the opinion that for taking into account the said submissions, the veracity of the medical reports of the physician, as well as the report of the medical board, would be required to be gone into. This court is further of the opinion. This court further takes note of the submission made by the learned counsel for the petitioner, that had the inquiry report been submitted to given to the petitioner, the petitioner could have further substantiated his case or could have substantiated his case and filed an appeal under Section 18 of
748.
the
Still lies under Rule 47.
Cooperative Apex Bank Assam Cooperative Apex Bank Limited Staff Rules 1980. Taking into account the above, this court is of the opinion that the interest of justice would be met if the instant petition is disposed of, thereby directing the respondent authorities, respondent number 2, to furnish an inquiry report to the petitioner. This court is also of the opinion that the veracity of the medical certificate submitted by the physician under whom the petitioner was under treatment, or the report of the medical board, cannot be gone into in the proceedings under Article 226 of the Constitution. It would be therefore in the interest of justice that the petitioner be relegated. It would be therefore in the interest of justice, as the punishment imposed is a minor punishment and the petitioner is still in service with the respondent number 1 bank. An opportunity, if an opportunity is given to the petitioner to prepare an appeal in terms with Rule 48 of the rules of 1980, In view of the above facts and circumstances, this court therefore disposes of the instant writ petition, thereby directing the respondent number 2 to furnish an inquiry report. The inquiry report to the petitioner within 15 days from the date a certified copy of the instant order is served upon the respondent number 2. And the petitioner thereupon is further given up 30 days period for preferring an appeal in terms with section rule 48 of the appeal against the order dated 23/8/2010. The record so produced by Mr. J.K. Goswami is returned.
Item number 5.
Advertisement was quoted by the Guwahati University for assistant professor anthropology. Now I participated along with the private respondent. Before a decision was taken, who is to be appointed? A caveat comes up. A caveat was filed, and I received one caveat in the post. The caveat was filed by the respondent number 3, saying that she has been selected. That's why someone may file a proceeding against the selection.
Before the order being passed,
Yes, before a decision was taken.
not an order, a decision was taken.
Yes.
Then
Then that peculiar situation led me to filing the instant writ petition. Now, during the when the matter was pending, then the Guwahati University filed their affidavit, and they said that subsequently they did took the decision, and the respondent number 3 was selected.
elected.
Now, my lord, 12 years have passed, my lord. We are not in contact with the client. Surprisingly, I was informed today by Mr. Bothakur that he is currently working in Arunachal Pradesh University as a professor. So, my lord, I am not on record, my lord. I didn't get my license when the matter was filed. So I cannot say that the matter has become infructuous or like that.
Yes, what is your source of information?
Lordship, I was informed after a lot of effort, Your Lordship, I could connect my client also, Your Lordship. And he told me that the writ petitioner is presently serving in Old National University, Your Lordship. Now that is my, in fact, Your Lordship, for long years, I did not have any connection with my client also, Your Lordship.
It is my duty to,
In fact,
my duty to submit, my lord, that the mark given in the by the selection committee that was not put on the list. So
and so
the
far as
situation-
that point is concerned, Your Lordship, filing a caveat, Your Lordship, I have Your Lordship filed my affidavit, and I said that after executive council approved the selection on 2/9/2011, the caveat was filed on 3/9/2011. After approval of the selection by the executive council.
When did the executive council approve?
2/9/2011.
What was the approval given?
Approval to my selection. Your Lordship.
And when was the order of selection?
Your Lordship, there is, Your Lordship, as far as the statute of the university, Your Lordship, once, Your Lordship, the selection is made, there is no procedure for Your Lordship publishing it, making it public, Your Lordship. And it was immediately placed before
You are appearing for
the selected candidate.
3, 4, and 5, 3, 4, 5, 6.
No, Your Lordship, that is, I am not for 3, 4, 5, 6. I am for 3 only.
What about the 4, 5, 6?
They have not, Your Lordship, come.
the service was completed.
Service completed. They did
Service
not
was completed.
And why no Guwahati University?
Guwahati University is not present today.
Who is the standing council?
PJ
Never.
Pukul. PJ Pukul.
They don't want to appear. And you have no contact. Means your senior has no contact.
And this matter came up suddenly.
This matter didn't come up suddenly. This matter was there on 17th. It was notified in the Telegram channel.
No,
Then-
madam, I didn't have any phone number, madam. That's why
You
I'm
don't
saying,
have the
madam,
phone number, that is
because I
your
didn't have
lookout.
the time to write. a
No,
letter.
I would have understood. Means, is it the fact that you don't, there's no contact with the client for all, if it is a matter of 2011?
No.
Then-
After November 2011.
Let us see who are the people who have filed the wakalatnama. Wouldn't that amount to dereliction of the duties by the lawyer? No. Wakalatnama khandeha. These people should be put to bar council. How can they have no contact with the client?
Rule was issued, madam. It was put up for hearing.
Whatever. So rule issued means, what do you mean by rule issued? Tell me. Yes, Mr. M.K. Chaudhary was there. He was a senior advocate then, so no problem. What about Mr. M. Dutta, A. Borkotoki, N. Bolwa? They are advocates on council. They are not there they are no longer practicing in the High Court. Then they are not bothered. Are these people no longer associated in your chamber? A. Borkotoki, N. Bolwa, M. Dutta?
Mr. Bogotoki is there.
Or is he less practice? Then why he couldn't appear before this court today?
He's currently on leg. He's currently on leg.
Where is he in which court?
Court number 7.
Fantastic. We'll look it out here. Let us see in the live streaming whether he is on legs.
I was informed he had a matter.
What is his item number? Number 7. Put number 7 is live streaming. Let us watch it as to whether he is on legs.
Otherwise, I can call. I can call him.
Call him. Because we can't take it on the basis of his statement. Because he may not know all. And if he puts it on affidavit, it's a different thing. He may say that I was wrongly informed and thereby to dismiss the petition.
Okay.
We'll take it up after some time. Ask that person to.
Item number 6.
Yes. Hello, woman. Yes, what is this challenge?
Hello, the restaurant number 7 and 8 selection and appointment was selected. Only in the interview, after the interview, there is a 0.60 marks difference with the restaurant number 7 and 8. And our allegation, my allegation was that after completion of the interview, at 1 p.m., I was again called back to appear before the interview. And thereafter, the result has been done and the appointment of the 7 and 8 in written test, I have got far better marks than. But the fact remains now, my lord, to be very fair, after 12 years, my client is also working now in a different post of the public office department.
He's working.
In another post.
He wants to leave that job and again participate. We have to set aside this. He has to leave the job.
Yes.
You leave it. If he leaves it, it is okay. Then we will be seriously contemplating, looking into it.
But
we won't take, because they have been already appointed 7 and 8.
yes, yes, yes.
I will not
And
set
subsequent
aside
to
that
that,
unless, because if you are not serious of living there and there's post goes,
But if I
get the set aside order also, this will not benefit me, my lord. That is a, to be frank. Because I have completed 11 years of service in that department, in another department. So what to do? Again, my lord,
Withdraw? I can't make it infructuous.
yes, my lord. I also cannot submit, my lord. The fact remains, my lord, I am an unsuccessful candidate and I have challenged this election. Lot of development of laws, my lord, already come.
Okay, but can you submit that he is working in PHE,
He is in public works department as president.
Public Works Department? He is working in Public Works Department?
Yes.
He's working in Public
No,
Works.
that information I don't have. But
No,
if
I
it
am
is-
asking you, Mr. Chaudhary,
Yes,
Yes, he is working.
in what capacity?
LDS is same,
Same post.
same rank.
junior assistant.
Nowadays, it is called junior.
And you are? LDA?
I am appointed there 2011. My appointment is under challenge.
LDA?
Yes, junior assistant.
Junior
Same,
assistant.
same ones.
Nomenclature is changed.
Response number 7 and 8 are in water resource division.
They get more salary.
My lord.
Do they get more salary? No, I'm asking you.
Same salary, my lord, because same rank, same.
You are working in Public Works Department in what as LDA? It's a
junior.
permanent post.
Yes.
Heard Mr. D. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. Then why did you file this amended writ petition in 2015 unnecessarily? You have joined out there in 2011.
I'm for the official respondents, madam.
Yes.
All the official.
Mr. B. Goswami, the learned additional advocate general or
Yes,
SC,
additional advocate.
additional advocate. You know the difference when you appear. That day I was looking into it, in fact, for another matter. When a person appears in the standing of an additional advocate general, he appears for the state of Assam.
That is why, madam, all the respondents. Or all
Ah. And when he is appearing for SC,
for
he
particular,
appears for the department.
only a particular department,
Because I was taking into account a particular matter
my lord.
where Mr. Dilip Mozumdar made certain submission as an additional advocate general. That means he's submitting on behalf of the state.
Certainly.
Then he can't say that I am only appearing for the respondent, for the department.
Here is a case where I pray for, that is, madam, for all the respondents. This is also there.
No, it's okay. No, I'm only saying that. He says that is
Yes,
what,
yes.
it has far-reaching consequences when it is the additional advocate general appearing, because he
Yes.
appears on behalf of the entire state.
For entire response.
He can say many things. Like the advocate general, he can say many things.
Right.
Appear for everybody because he has the overall lead.
But for sometimes for specific cases, madam, specific department, standing councils are there.
No, understood. The standing council will be there. But then if he is mentioned as a standing council,
Right.
then he is only confined to that department.
Yes, absolutely.
Because then you can't, his submission cannot be brought as a submission for the entire state.
Yes.
Mr. B. Goswami, the learned additional advocate general, Assam, appears on behalf of the respondent state. Mr. B. D. Goswami, the learned counsel, appears on behalf of the respondent number 7 and 8.
Not 7, 8.
Huh?
7 hasn't come.
7, 8
8.
on behalf of the respondent. None appears on behalf of the respondent number 3, 4, 5, 6, and 7. The instant writ petition was filed challenging the selection of the respondent number 8 in the post of the junior assistant by office order dated 133 dated 28/9/2011. It appears from the petition that there are various grounds assailed. There are various grounds taken for challenging the said selection selection and appointment made of the respondent number 8. Be that as it may, the learned counsel appearing on behalf of the petitioner had submitted that for the last 11 years, the petitioner is engaged and appointed to a permanent post.
It will be matter 10 years, sir. I'm sorry, 10 years.
10 years. The petitioner is engaged and appointed to a permanent post as a junior assistant in the Public Works Department. And allowing the instant writ petition would not serve the purpose of the petitioner, as he had already he would otherwise not serve the purpose of the petition. Taking into account the above, this court is of the opinion that issuance of a writ of certiorari, as has been sought for, would not be in the interest of justice. Accordingly, the petition stands closed.
For orders, item number 7.
My lord, as per office note dated 14/6/23, lordship, AD card of respondent number 4 and 5 has not been received back.
What is this?
This is an
Why it has come up for order?
orders, it is not yet received, lord.
Huh?
Service report is awaited, lord.
Who has made it by order?
Lordship, I have made.
Why?
Lordship, matters pending till 2018, Lordship.
Service upon whom?
4 and 5, lordship, they have already received 50% receipt, lord.
Who has received?
Claimant received the
You
money.
pay the remaining. You want the service upon respondent number 5, pay the remaining.
Lordship,
You file an I.
learned code.
You file an I. We'll give asking to deposit the 100%. We will wait for 4 and 5.
Lordship, we may be allowed then take step to paper publication. Lord.
Absolutely. Absolutely. Take service by justice, not proper.
Lordship, we'll take.
Where are these people?
They are from 4 and 5 from Kohima and Nagaland.
As reflected in judgment, that also learned code bill also they were not appeared, Lordship. Owner and driver respondent number 4 and 5, Lordship. It is reflected in appeal page number 8, Lordship. Paragraph 4, Lordship.
4 and 5 did not appear.
Lordship.
And what is it? What did the trial court hold? Tribunal hold?
Awarded compensation against us, lordship, but to our
Only
plea was that, lordship,
entitled to take payment of the amount that cannot carry an interest of the people. The policy was valid.
Police was valid, Lordship.
Then why do you need 4 and 5?
Lordship, regarding DL, Lordship. Regarding DL,
What does the court hold as regard to TL?
yes, Lordship, but it's not correct, Lordship.
Therefore, the claim of the insurance has not been accepted, and accordingly it is held that the driver was authorized to drive the superbus, and therefore the owner had not violated the terms of the. What is this superbus business?
Lordship, this is PSB endorsement was not there, Lordship.
Huh?
The driver was not authorized to drive PSB, Lordship. That is superbus. It's a big bus, Lordship. And he has not authorized
OP
to
has
drive
failed to
that vehicle.
rebut the state evidence. So, in the above discussion, it appears that the accident was caused due to rash and negligent driving on the result of which right.
Driver and owner are the necessary party, Lordship. Here. So I may be allowed to take steps to paper publication.
Here, the direction to recover has not
No,
been
no,
given,
not there,
obviously,
Lordship.
because
That's why we have filed, Lordship. Recovery was not there. We have proved our case, Lordship. That
you
order
file
is
an
not
I
there.
for paper publication.
I have to file an I, Lordship.
I would not allow it. You file an I within 15 days
Lordship.
for paper publication. And if you don't file it, then we will take the matter on the basis of which. And if they don't file it, you file an I for the 100% with interest.
Not applied.
Ms. M. Chaudhary, the learned counsel appearing on behalf of the appellant, and Mr. P. Gohai appears on behalf
One,
of the
two, three,
respondent number 1, 2, and 3. It reveals from the records that this is it reveals from the records that although the instant appeal is of the year 2018, and notice was issued as far back as on 17/12/2018. But till date, the service upon the respondent number 4 and 5 is not complete. The learned counsel appearing on behalf of the respondent numbers 1, 2, and 3 submitted that in view of the delay in the disposal of the instant appeal, the said respondents are suffering Ms. M. Chaudhary, the learned counsel appearing on behalf of the appellant, submits that she may be permitted to take effect service through substituted mode. This court is of the opinion that such prayer has to be made by way of by filing an application. The appellant insurance company is directed to under such circumstances, this court fixes this matter on 19th of July. No. 19th of July. On which date? 19th of July.
I'll file an application. But within this short period, the
No,
office will not.
once you file application, then I can pass an order.
Lordship.
How can I pass an order now?
Not obliged.
I'm
Item
not
18,
directing. I can't direct you.
Lord.
You don't file it, the consequences will follow.
Lordship.
Yes. Mr. Ganguly, what is this?
No, no, this IA was earlier taken up once by your lordship, and in fact, the lordship had directed the matter to be listed.
Name shall
It
be
was
made
in
to
fact
the
listed,
second
my lord, for
appeal,
hearing, but
however, in case the case are
somehow,
not,
my lord,
they have gotten to press the instant application. Yes, what is this IA for?
no, that IA is there, my lord, for early hearing and disposal, and there is an order of a lordship of 28th of September, my lord, 2022. Lordship have, fact, in a way, allowed the IA, directed that there should be an early listing, considering that the appellant number 2 was an infant when his father expired in an accident. Now he is a graduate also.
Where is the question of law frame? I do. Oh, we have only one substantial question of law.
In fact, my lord, there should have been another. I have a proposed additional substantial question of law. So, my lord, both the courts below have, what has happened in this case is that, my lord, there are two branches of the family. The present appellants are the wife, my lord, and the child of the deceased who was a bank official. And the other branch, my lord, who are also there are two title suits. The other branch is the mother, my lord, and the sisters of the person, the retired. And he was admittedly a Christian person, my lord. The learned courts below have said, my lord, that the marriage between the deceased and the appellant number 1 was not a valid marriage, because the appellant number 1 happens to be a Hindu and the deceased was a Christian, my lord, and there was no convincing evidence of his conversion to the Hindu religion, and therefore, my lord, he continued
Who?
to be a Christian. The deceased, the
Appellant
husband,
number 1.
yes, the husband of the appellant number 1 who expired, who also happens to be the son and the brother of the this respondent number 2.
Wait. Now, who is appellant number 1?
Appellant number 1 is Rinki Musahari, madam.
He married whom?
She married one Ripul Musahari, madam. And Ripul Musahari was a Christian, madam. He was serving in the Central Bank of India, which is the respondent number 1, madam. He
It
expired.
was the second marriage.
No, it was
First marriage.
First marriage only, madam. And the marriage took place in a
And
Namdor.
did that person marry again somebody?
No. There
So
is
he
no other claimant.
Okay, so there is no other.
Yeah.
So it is now the question is as to whether the marriage should be stayed to be done.
That is one part, my lord. And the other part is that if the marriage were held to be not a valid marriage, as the learned courts below have held, my lord, then what would be the consequences of the property and my lord, the death benefits? Because those death benefits are still with the central bank, almost 20 years or more of the after the death. Because
Who is for central bank? Central bank won't have any objection.
they will, my lord, abide by the decision of a lord.
And who are you?
My mother,
You want the entire money.
I want. Mother and sisters.
Mother and the sisters also. There are 4 sisters and the mother, mother.
So the trial court and the first appellate court is a concurrent.
Concurrent.
Concurrent, my lord. And both the courts have held that one, my lord, that the marriage was not valid. And the second part is that the shares will be, my lord, between the son, because the son cannot be held to be illegitimate, my lord, and the mother and the sisters. So it is effectively, my lord, 6 shares.
So you don't get it.
No, the appellant number 1 doesn't get.
Who is the appellant number 2?
Why?
The appellant number 2 is the son, my lord, who was an infant.
Son will get it.
Son will get it. Son will get 1 share, and the other. That is the view of the learned courts below. But, my lord, the
Son will get and the other will, the mother will get.
other,
and
the mothers and the sisters have also been given shares. That is the issue.
How will the sister get it?
That is the crux of the question, my lord, because there are 2 ways in which they will get it, my lord. The decision had to be taken. Now, both the parties.
This person, Ripul Musahari, was Hindu or Christian?
Christian. He was admittedly a Christian.
And how does the Christian succession happen?
The Indian Succession Act.
What does it say? How?
Indian Succession Act, my lord, very categorically says.
Does it have a class 1, class 2?
Yes. No class 1, no class 2. My lord. Those legal ads are totally different, my lord. And in fact, sister does not come anywhere. Now, what has happened in this case, my lord? None of
Who is representing the sisters?
he is
I am representing.
You are representing the mother and the sisters.
Yes.
Mothers is entitled. Mother is
So giving it to you will solve a lot of problems.
Yes, because for instance, if your
Okay,
lordship
let me
holds-
come back.
Sure.
I'm coming back in fact. I'll take Mr. Bokotoki's matter first.
Okay.
Uh, 299 of Indian Constitution.
Huh?
Appeal under 299 against Lordship, one against.
So they are
rejection of probate.
appellants. They are appellants.
Appellants, they should be appeal, but they are registered at that point of time as testamentary
These people
cases.
keep on mistake. Last time also I found out something.
That's
Appearing on behalf of the appellant.
appellant.
To submit that the matter has been amicably resolved amongst the parties, and as such, not like to press both their feet. Taking into account the above, the instant appeal stands closed on withdrawal. Return the LCR.
Item 12.
May it please your lord.
Hmm.
My lord, this is the second appeal your lordship will find, my lord, against the interim judgment and decree of the plan at court bureau, my lord, ignoring the evidence and materials in the case record. Now here in this case, my lord, the present appellants, your lordship, they were not the defendant, my lord, in the original thing filed in the suit. And subsequently, my lord, they are added defendant. After, my lord, they were added, they filed a written statement to your lord. But that written statement was not accepted, and they were also not allowed to adduce their evidence to your lordship, which has resulted.
Can it be taken after some time, my lord? Mr. Roy is on legs.
Who?
Mr. Roy, PK Roy.
Let him come. Let me get the hold of the matter.
So, my lord, at the
Let us
time
see
of-
what are the question of law framed.
My lord, firstly, my lord, ground. by
Whether
which
the
has
learned
taken-
court below is right in decreeing the suit of
No,
the plaintiff
25.
without recording any finding as to whether the plaintiff's vendor had right title and interest over the land in question after the promulgation of the Assam State Acquisition of Dominatory Act of the plaintiff for declaration of right title and interest without praying for consequential relief is maintainable.
29/5/2019 order, your lord. That is, yes, my lord.
Yes,
And,
that I have seen it.
Lord-
So the first thing is that there is some Assam State Acquisition of Jamindari Act 1951.
Because what, my lord, this land, my lord, from the plain your lordship will find is a permanently settled.
Hmm?
Permanently settled.
Permanent?
Permanently settled estate, your lordship.
Okay.
That is mean this land was a Jamindari estate, your lord. Now, they had purchased, my lord, from Exhibit 2 and
You are
CC.
the defendant or the plaintiff?
We are the defendants, my lord, added defendant. Accordingly, your lordship will find in the plaint our name is not there. Ultimately, we are, my lord, added as the defendant.
No, it is there from the 4 to 12.
Initially, my lord, this plaint your lordship will find against the, my lord,
Deputy Commissioner, Settlement Officer and the State of Assam.
Settlement officer and other your lordship.
And then 4 to 12
And
were made.
then, my lord, we were added. 4 to 12, your lord. 4 to 12, we are added. And your lordship will find their plaint, my lord, at page 35, your lord. Page 35, my lord, we are not there.
Okay.
As the defendant. Now, my lord, they say, my lord, paragraph 2, my lord, this is their case, that they belongs to one Jogindra Charan Das of village so and so, and after his death, his successor sold the land to the, my lord, predecessors of the plaintiff, grandmother of the plaintiff, by still did no 74, then 76, then 82 from the legal heirs of Jagannath, the Jagannatha Charan Das. Now, if your lordship goes into this deed, then your lordship will find Exhibit 2 with it, my lord, they purchased the Mirasdari, that is the Jomindari right. So after my lord, acquisition of Jomindari, your lord, what right, my lord, this Mirasdar had over this land.
Who are you?
I am, my lord, I was a tenant and I purchased the, my lord.
Tenant under whom?
Tenant is under the, my lord, actual proprietor of the land, your lord.
Who?
We purchased, my lord, we purchased this land prior to the acquisition of the Jamindari.
You purchased by how did you purchase?
We purchased the, my lord, occupancy right on under the Jamindar, there would be a tenant, your lord. And that tenants, my lord, who were there in possession of the land, they sold this land to us.
No, you were the occupancy tenant.
Yes.
Under what provision?
My lord, we had submitted some, my lord, sale deed. We had 2 or 3 sale deeds. But it's because, my lord, in our returns, we had in fact filed a written statement also. In this written statement, my lord, everything was mentioned. But written statement itself was not accepted, your lord. So our written statement, my lord, in this case is not a part of the recording.
Why was it not accepted?
My lord, your lord, you may kindly, my lord, turn to the, my lord, trial court judgment, your lord.
Okay, just 1 minute.
Trial
Let
court
me go.
judgment.
No. Let me go through the plain code.
Page 26, your lordship.
No,
Bottom,
wait.
at the
Just,
bottom.
Mr. Dhar, just take your seat. Let me go through this. At all, only one thing is what is difficult to understand. See, from the facts it reveals that after the death of Asalatar Datta, her only son, the present plaintiff,
My lord, that is a mistake, my lord, from that part. Not only son, so many sons, my lord, plaintiffs are there.
now, how does the plaintiff's name is not there?
It is their contention, your lord.
No, this I
That I
could
have-
see it also in the plaint also.
That I have seen a lot yesterday
Hmm.
while I was preparing. And I have put a question mark how they could say only son. Will be only son. Your lordship is reading the plain most correct.
No, plaint I have done it. Plain written statement I have read it. I am now reading the trial court judgment.
Yes.
I am reading the trial court judgment.
And your lordship appellate court judgment without any point of determination, without any issue-wise decision.
Let me.
All these your lordship. Fine.
Yes, please take your seat, Mr.
Fine.
Night, dear. Night.
Hey, continue. Mr. Dhar,
What?
tell me, how does the first substantial question of law arise?
My lord, on the day, my lord, when the matter was, my lord, picked for admission, my, then we formulated some substantial question. of law.
Understood, but how can you raise that when you didn't have any pleadings? When you did not take this issue also in the first appellate court?
My lord, this is formulated by the court, your lord.
No, court, how
Now,
can the
we
court
filed,
formulate?
my lord, a separate, my lord, substantial question of law, my lord, on the same day, but court.
No,
edit, my lord,
this
my
can't
lord,
be a substantial
now, my
question of
lord,
law.
our substantial question of law, my lord, from this memo we have filed in the case record, that whether the impugned judgment and decree passed by the learned court below, my lord, ignoring the evidence of PW1 and PW2 and my lord, exhibit, my lord, E are sustainable in law. And whether, my lord, second, my lord, whether the impugned judgment and decree passed by the learned court below, without allowing the added defendants, my lord, to file their written statement and without an opportunity to adduce their evidence are substantial question.
No,
of
this
law.
can't be a substantial. Number two can't be a substantial question of law. How can you raise this as a substantial question of law? You were given an opportunity, period of 90 days was over, and can you raise it as a substantial question of law now? When you did not raise that in your first appeal? You looked into the grounds of first appeal.
First appeal, your lordship, without any point of determination, your lordship, without any.
No, that is another aspect. We are not on that. In the first appeal, you never take the ground. That is why I was looking into your first appeal, memo of appeal. What is your memo of appeal? What are the grounds you have taken? Not taken the ground that you are about the filing of the written statement.
Take a little.
No?
So, past substantial question of law, my lord, is my lord, your lordship.
That is a question of fact.
For an appreciation, my lord, your lordship.
No, Mr. Dodd, the first substantial question, these two substantial questions doesn't arise, but here as regards number one.
My lord, your lordship, my lord, Hajari stays or my lord, the Chirtas stays, your lordship. Your lordship is not precluded, my.
For?
From my lord formulating other substantial question of
No
law, my
quarrel
lord.
with that, but as regards the two substantial questions which you formulated, or where you have placed out there, the second does not arise because of the fact that you did not challenge it in terms with 105 against that.
My lord,
Number two goes.
my lord, if I have not raised, my lord, I agree that second doesn't arise.
Yeah.
Now, so
Now
far as
let
the
us see number
past
one.
is concerned, my lord, I
Whether
am
the
on past
impugned
one, your
judgment
lord.
and decree passed by the learned court below, decreeing the suit filed by the plaintiff, respondent plaintiff without discussing the evidence of PW1 and PW2 and ignoring exhibit E in the case record, and accordingly without any proof of title of the vendor of the over the suit land are perverse and unsustainable under law.
So there is no finding that the vendor of the plaintiff, my lord, he had title over the suit land, my lord, in entire, my lord, judgment of the trial court or that of the appellate court, your lord. Now, my lord, what is exhibit H, my lord, exhibit E, your lordship. Now, your lordship, for that,
No,
your
we will
lordship
go into exhibit
will have to
E.
go, my
Let
lord,
us
into the-
first look into how issue number 3 was taken into consideration by the learned trial court first. Let us see. We are concerned with issue number 3.
Issue number 3, your lordship will find, in view of the facts and circumstances of the instance, the issue appears to be most vital, and thus same is taken up first for consideration, your lord. The present plaintiff of the suit examined SPW1 and reiterated plans to on also exhibited as many as 4 parties did. And he said, my lord, the suit land covered by tag number 5250 was not mentioned in the child deeds here law. My lord, I will be going into the evidence of PW through my lord cross-examination part. Another witness, namely Gopika Ranjan Sen, is examined as PW2 and he corroborated the evidence. My lord, I will also go into the evidence of PW2. Cross-examination part was not taken into consideration. It is an admitted fact that plaintiff is in possession over the suit land and is support of the title. The plaintiff had cited original purchase deed of 1974, 1976, and 1982 year lot. And all these after my lord, after acquisition of my lord Jamindari Act 1951. What happened to this land after acquisition of Jamindari Act? And those documents were not challenged in the suit, although Kachapatta in respect of the suit land is challenged. But Patta follows the title which came to the landholder of the instant suit by a party being one of the moves which is applicable in the suit. And if the basis of source of title is not challenged, one is precluded from denying the follow-up documents of the same, and thus the defendants of the suit are on the footing of waiver, which is apparent on the face of the record. That is, with reference to defendants number 1, 2, and 3, my lord, who filed the suit and contested the suit. Now, further, the added defendant side issues some photostat copies of sale deeds, which are of the year 1936 prior sale deed, your lord, 36, 1939, but during DP proceeding, they did not take part, and there is no DP proceeding, my lord, these were set aside by the revenue authorities, your lord. Proceeding, they did not take part, and there is no explanation on the case record as to show that they have knowledge about the proceeding, and they have also did not approve the authority concerned about the settlement record, which when the suit land had been recorded in the name of the father of the plaintiff. My lord, Assam Revenue Board, my lord, the plaintiff has done, matter was remanded, and during the pendency of the proceeding before the my lord Revenue Board and settlement officer, they all of a sudden they filed the suit. And after, my lord, during the continuation, my lord, of the my lord suit, an order was also passed. My lord, Exhibit E, they say, and my lord PW1 prove Exhibit E, that Exhibit E order, my lord, so far as the collection of friend record is concerned, my lord, was not challenged by the plaintiff. So plaintiff, my lord,
Plaintiff did not challenge what?
Exhibit E, your lord.
Exhibit E is that order of the Board of Revenue.
No, after, my lord, firstly DP case, your lord. If your lordship goes into the my lord, their prayer person. Firstly, my lord, they say that DP proceedings, my lord, prayer D, they say it is correct. A declaration is to be made. Now, DP proceeding, my lord, was, my lord, set aside by the settlement officer in appeal. And, my lord, by order dated 24/2/1995, prayer number 2.
Let us see with Exhibit E.
Now they say for declaration that the plaintiff is not bound by the order passed by the defendant number 2.
Exhibit E is the 2025-7-2001 order issued by the settlement officer. Yes.
That was not received, that was not challenged, dear lord. And it remained, my lord, saying that the plaintiff do not have title over the suit land. Legally or illegally, my lord.
No, but the fact remains, maybe this order is there. But can the settlement officer decide on the title of the suit?
Settlement officer says they could not find any proof regarding that title and
Understood, but that is only for the purpose of settlement purpose. That cannot be said that he can say that.
Position, my lord, settlement officer on the basis.
It is ordered that half of the ponds so and so be recorded in the name of the. Now, who is the petitioner out here, Mr. Dhor? Who is this person? Nirandu Saha?
Niharendu,
Niharendu Saha.
Niharendu Saha is one of the defendants, your lord. Our predecessor, your lord.
So it is in the name petitioner. You have filed a particular case before the settlement officer.
I filed an appeal, Miss mistake.
Miscase 5 of 1991-92.
151 of the Assam Land and Revenue.
Yes.
And my lord, this by order, my lord, 24 to 1995, the DP case, my lord, which was passed by the assistant settlement officer was, my lord, modified or set aside, your lord. Plaintiffs were active. So plaintiff plaintiff number 4, PW1 came to the court. He sometimes says the OP went to the appeal before the against this order of the settlement officer before the Assam Board of Revenue, and ultimately said that the plaintiffs are gone.
What happened to the Assam Board of
And
Revenue?
at this stage, my lord, Assam Board of Revenue, my lord, remanded the case to the settlement, saying that you are to decide the case with view of Assam adoption of relationship, my lord, Assam landholding adoption of relationship after acquisition of this land by the Jomindari Act, and these things, your there is a separate act. Earlier, my lord, Select Tenancy Act is there, and under the Select Tenancy Act, my lord, assistant settlement officer passed the order in DP case. Then there is a settlement survey, your lordship. So settlement officer said that during the settlement survey and during my lord,
But whatever may be, Mr. Doctor, this order is wrong. The settlement officer cannot decide on title. The civil court has decided that. What is the business of the settlement officer? Can the settlement officer, his requirement is for settling. Well, look at this. Have you seen Exhibit E? See that order.
No, I have seen, your lord.
Yes. Now
But-
coming to the question of prima facie title and the possession on which framing of land
Possession, your
record
lord.
always rests, the subsequent and important issues are now as regards so and so, as regards title of so and so. On the other hand, the petitioner side has proved their title and also proved their possession over the land measuring an area of so and so. In the context of it, it is ordered to so and so, so and so. This order cannot have it.
Now, my lord, they had purchased from the legal heirs of Jogindra Das. They say Jogindra Das was in occupation. Jogindra Das, my lord, title was not proved over this land. No finding that Jogindra Das, my lord, Das was having title over the two land, your lord, from whom the plaintiff has purchased, your lord. So that was the lookout of the civil court, that whether the vendors of the plaintiff had title over the suit land after acquisition of Jomindari Act and all that, or prior to that. But after this acquisition of Jomindari Act, because it was a permanent, or prior to that.
This court is not going to look into that. That was never a question before the trial
My
court.
lord, let us, my lord, forget this Assam state acquisition of Jomindari Act.
Good.
Now, my lord, whether he is having title, it's in any way, my lord.
No, he has proved this title on the basis of those deeds. That's all.
No,
And the court has come to a finding of fact. Why should this court interfere?
His sale deed, your lord. They have proved their sale deed. Plaintiffs have proved their sale deed. Now, sale deed, in that sale deed, they say they had purchased from common person, Jogindra Das and legal heirs, Srimod Das and all that. Now, whether these people had title, my lord, there is no proof. No
Title of what?
over this particular land, suit land, your lord. Their vendor, whether the vendors of the plaintiff is derivative title, your lord. They had purchased from somebody who were having title, the derivative title. So whether their vendor was having title, if their vendor is having title over this,
Where is your denial to that?
well,
Where is your denial to that? That the vendors did not have title?
will you do in the written statements of OP number, defendants number 1, 2, and 3,
Yes.
they had stated categorically that this vendor of this, my lord, plaintiff did not have title over this land.
Where is that?
My lord. My lord, this is 42. Page 42. My lord, firstly, they say, my lord,
As per the revenue record, Sri Jyotish Chandra Das, son of Jugendra Chandra Das and 6 others were the recorded owners. page 43. The revenue records were prepared as per the record of rights during 55, 56, 68. The statement of ownership also as stated in so and so are not correct. That is only for this. It is not correct that on the date of so and so imam. As per the revenue record, Jyotish Sonada, son of so and 6 others were the recorded owners. Then, and this purchase was made from Jyotish, this person, Jyotish Chandra Das.
No. They purchased from somebody else, not this Jyotish and all that here.
The plaintiff's mother acquired the property described in so and so by registered date from the heirs of Jogendra Chandra Das, and as such the plaintiff's mother. So it was categorically mentioned in the written statement.
As per revenue record, the Jyotish Chandra Das, son of the Jogendra Chandra, 6 others were the recorded owners.
So this is an admitted fact. They were the record, and from there the plaintiff purchased it. They are only denying later on. The statements regarding ownership as stated in para 2 are not correct. It is not true that plaintiff is the owner of the land described in so and so. The statements made in so and so as regards. These the court have done it on the basis of the appreciation of evidence.
They did not purchase from Jyotish Das. Deeds are there. Exhibit 2, 6 and all the sale deeds are there. They did not purchase from Jyotish Das.
No. This, he doesn't say Jyotish Das alone. Jyotish Das, son of so and 6 others.
Now, who are that 6 others?
6 others are there, whose names are there, and it is the specific stand of the plaintiff to that effect.
Now, statement is here into that.
See, this was purchased from the sale deed. Yes, Mr. Chakraborty, you have exhibit 2.
No, my lord.
Exhibit 2, my lord, Suitland is not mentioned. He admits PW1. Suitland is 5052. We are concerned with 5052, and PW1 says that in their sale deed, my lord, I like to go to the, my lord, evidence of PW1, and he admits that this land was not mentioned in that sale deed.
You see, act number is so and so Das Nas Iman Da, in number Iman, Tari number Iman, and so and so.
And the suit is basically for correction of land records here.
Huh?
Suit as per prayer, my lord, other than title and position, they paid for correction of land record.
Then?
Correction of land record, my lord, it is basically, my lord, the duty of the revenue authority.
The revenue authority have decided in this manner, so they should have normally gone and filed for the Assam Board of Revenue, but they sort of filing an appeal for seeking declaration. Now that declaration cannot be made by the Assam Board of Revenue. Mr. Dhar, rightly, you have stated one thing. The judgment of the first appellate court and the trial court, this court is not so pleased with the judgment. They should have been more elaboration. But all said and done, Mr. Dhar, you are there for so many years in this profession. For this court to interfere in under second appeal, there is no case made up.
At least the appellate court judgment here, Lord.
No, not on those aspects, because you see, it is whether that, yes, Order 41, Rule 31 says that you have to frame your points of determination, but the court took it up issue-wise and decided, issue-wise means he has taken up that each, all the issues were taken up as points for determination.
Issue-wise decision was also not there, Lord. We all respect.
No, but you see, one thing is that there is no evidence, there is no reply. The defendant, the state authorities also should have given any evidence. Nothing to the effect.
Lord, my lord, we did not, our written statement was not accepted, so giving our evidence would be meaningless. And
No,
still-
your evidence, I'm not saying. The evidence of the defendant,
Now,
those
your
who have
lordship
filed,
may
the
have called, my lord,
the
we
state
can
should have
say
filed
that
it.
The evidence, my lord, plaintiff, my lord, is to, my lord, win his case, my lord, standing on his own foot, your lord. He cannot depend on the weaknesses of the, my lord, weakness of the defendant, your lord. Now, what he has said, my lord, PW1 in his cross-examination, your lord, you may kindly see, your lord. My lord, cross-examination of PW1, I am, my lord, reading, your lord.
Where is Mr. Roy?
He's on legs.
Huh? Should I finish up the matter before he comes
My lord.
and put it none appears for a respondent? Yes. Yes, where is the cross-examination? Yes, read it. Let us see his evidence in before the defendant have submitted. We are denying the contents of the. Yes.
PW1 have you lost? My lord, cross-examination. I'm not going into the chief, but cross-examination, your lord. This suit is filed for 0.01 acres out of 0.74 acres of land.
Where you are reading?
My lord, cross-examination of PW1.
It's in Assamese?
Oh, no, in English here. English.
No.
My
Cross-examination?
lord, we have certified copy here.
Where? Oh, examination in chief of Joy Gopal Datta.
Jai Gopal Datta.
Who is this then that the person earlier? There's another one, na? There's two cross-examination. One is in Assamese also. Held on 7th of September 2009, 1999.
2005, your lord. 19/7/2005, my lord, cross-examination.
Cross was on 5/7/2005.
19/7.
19/7/2005. Yes, the second part. Yeah.
Cross-examination. This suit is filed for 0.0 acres of out of so acres of land. Suit land covered by tag number 5250. But I cannot say the Satyan number. My grandmother purchased the suit land in 4 deeds in the year 1972, 1972, 1972 from Jogendra Chandra Das of the Pradhan. The suit land is bounded as follows. They have given the boundary. Then I have submitted all the 4 purchases in the court. I cannot say whether land documents of Jogendra Chandra Das has been obtained. Jogendra Chandra Das has been obtained by my predecessor and the same has been deposited in the court or not. So Jogendra is the, my lord, vendor.
I know.
Now, my lord, it is not a fact that Jogendra Chandra Das was not the owner of the land covered by tag number 5250. In miscase number 2, the settlement officer surveyed the suit land and recorded the names of predecessors of the defendant number 4 to 12 in settlement record beyond our knowledge, and we prefer appeal against the state order. Our Shopa is standing over the land covered by the number 5250. 5250 is a pond, dear lord. How the two, my lord, from the plain description here. On acres on 0.1 acres of land, but I cannot say the length and breadth of the suit house. I do not have idea of the area of the land measuring 20 acres. On the east of my shop is the west census. On the west census of residences of the legal heirs of census. On the north of house, now he is giving boundary after recording predecessors of the defendant. We entered appearance in case number 5 of 1991. Under section 7, so are including from it is not a fact that in 1/6 but predecessor of the defendant number 4 to 12 have been occupying the same being purchased land of registered 1936. Our land, your lordship, we purchased the land in the year 1936. It is not a fact that we have submitted.
In fact, this couldn't have been even brought in cross-examination. Why should this court at all take into? You can't lead your defense.
Before this court, Exhibit A and Exhibit B are the notice upon my grandmother in connection with the miss case number 5 of 1991. Exhibit C is the copy of statement. Exhibit D is the copy of the order dated 24 to 1995. Miss case number Exhibit E is the certified copy. So they know about the passing of the order Exhibit A, D.
Understood, but Mr. Dhar, kindly tell me again by way of by today the settlement officer declare a title.
Now, my lord, Exhibit E is the certified copy of the, my lord. I am coming, my lord, order to so and we enter appearance in certificate WS. And the matter has been finally disposed of even after remand. I cannot say whether copy of notice under section 8060 has been served upon the defendant. In deed number Exhibit 2, there is mention of my shop, but there is no mention of tag number 5250, your lord. Most important. In their deed, my lord, there is no mention of the disputed suit land, my lord, covered by tag number 5250. In deed number so there is no mention of tag number 5250. And 5250 is the, my lord, disputed land.
See the next line. In deed number
in deed number so there is mention of tag number 5250. In deed number 6, there is mention of tag number 5250. I cannot say by deed number so what area of land has been purchased. You cannot say the area of land even. It is not a fact that the Exhibit 2 to Exhibit 6 does not attract suit land. The vendors of the aforesaid deeds have no right, title, and possession over the suit land. It's saying, my lord. The vendors of the
No. Mr. Dhar, before you read it, I've already read it. Prior to that, it is not a fact. Then all these things are recorded.
So, my lord, what, my lord, we have found out.
You, Mr. Dhar, you want to transform this court from 100 to 96. You want that? That this court should exercise as 96, not 100. By appreciating all this evidence. Let me come back at 2.
I think, my lord,
We'll come back at 2. You are new. Nowadays, we rise at 1.
They are not filed counterclaim whatsoever, my lord. And they have also not filed in written statement. They have filed, but it was not there. And everything is admitted as a concurrent finding, lordship.
That I have seen. Concurrent finding is that there. But you see, the first, there were 2 substantial questions of law
Yes,
which
but
were framed.
I find, my lord, this
One was as to whether the learned court below is right in decreeing the suit of the plaintiff without recording any finding as to whether the plaintiff vendors had right title and interest over the land in question after the prayer. This is not a. This can't be there because of the fact that that was never raised at any point of time.
and they have admitted in WS, my lord, they say the vendor has the title.
So that the respondent. Now, can you come to number 2? Whether the suit of the plaintiff for declaration of right title and interest without praying for consequential relief was maintainable. Now, this is on section 34, the proviso to
That's the
section
proviso.
34.
But my lord, the confirmation possession is there, number 1. Secondly, my lord, even otherwise also we can, my lord, after getting this decree, we can always go to the revenue code if there is anything left to be done.
Confirmation of possession is there. Confirmation is consequential
is there.
relief. So that is also not a substantial question of law. Now, Mr. Dhar have raised further 2 substantial questions of law to that effect. There is a substantial questions of law, Mr. Dhar, today you have raised.
That we have filed separately on 25/5.
Got it. Whether the impugned judgment and decree passed by the learned court below, decreeing the suit filed without discussing the evidence of PW 1 and 2 and ignoring Exhibit E in record without proof of the title of the vendor over the suit plan are perverse and unsustainable. And whether the impugned judgment and decree by the learned court below rejecting the written statement filed by headed by the defendant in the suit and accordingly without affording an opportunity to the wing, that also does not arise. But Mr.
Lastly, my lord, my submission is that, my lord, last submission.
Yeah.
Now, exhibit 2 to 6. From exhibit 2 to 6, your lordship will find what the plaintiff has purchased. They have purchased the Mirasdari right. Mirasdari, my lord, it's written there in the LD. Exhibit 2 and 6. Mirasdari means, my lord, Jamindari. Now, Mirasdari or Jamindari, my lord, these were acquired by the government of Assam. Now, what right they had, they are having, my lord, we do not know. And so far as, my lord, this exhibit H, exhibit E is concerned, my lord, for correction of the, my lord, land records or for mutation of the names of the plaintiff, my lord, two requisites are required, my lord. One is title, other is position. Now, that is, my lord, Goya Prasad Thamani's case, your lordship. But
What did you say? What is your submission?
other things are, my lord, other than this declaration of title and confirmation of position, they made some, my lord, declaration so far as the correction of land records are concerned. So at the time when the exhibit E order was passed, my lord, there was a, my lord, court state, my lord, settlement officer said, my lord, defendant number 2, that the plaintiff do not have title and position over the system. Now, Goya Prasad Thamani's case, my lord, said that if there is no title, he has to consider this settlement officer that whether the petitioner or a particular person seeking mutation or correction of land has the title over the suit land. So, the settlement officer committed no wrong in view of this decision. Your lordship, paragraph 4 may your lordship may kindly. Firstly, my lord, Assam Land and Revenue Regulation conditions for grant of mutation, that is the correction or recording of their names and this thing, my lord, Revenue Board. My lord,
This
firstly,
is for grant of mutation.
mutation means
Mutation is for what?
mutation of the names of the plaintiff.
But Mr. Dhar,
My
Mr.
lord,
Dhar, if you were on the
ultimately-
other side,
ultimately,
no, Mr. Dhar, if you were on this side, I know your submission would be mutation is only for the purpose of payment of land rate.
no, my lord, this judgment is otherwise, my.
These judgments can't be
judgment, your
more than that.
lordship says-
The law is very clear from all Supreme Court judgments. Mutation is only for the purpose. Right from 1961
says-
onwards, every
Court-
judgment is
Our
there.
High Court says, my lord, Goya Prasad Thamani's case that for the purpose of mutation of correction of land record section, my lord, 50, 53, title is a prerequisite.
Yes, there's no quarrel with that.
So, my lord,
But
settlement-
there is no quarrel that for the purpose of mutation, you require title as well as possession.
Yes. So, my lord,
You
settlement-
don't require a judgment for that. Section 53 is clear
my
for
lord,
that.
So, my lord, settlement officer says in exhibit-
But can the settlement officer declare title?
No, he did not declare, my lord. He did not declare title.
Then if he has not declared title, why not the civil court can declare?
He did not, my lord. This order was passed, my lord.
Okay,
prior to
Mr.
the
Dhar.
judgment passed by the civil court, your lord.
Mr. Dhar, I give you this opportunity to argue. Nowadays, you are in Delhi, argue in the Supreme Court on these aspects. Yes. Heard Mr. Andhar, the learned counsel appearing on behalf of the petition appellates. Mr. P.K. Roy, the learned counsel appears on behalf of the respondent numbers
1 to 5.
1 to 5. The UDAS appears on behalf of the respondent number 6 to 8. The instant appeal was admitted by this court by an order dated 29/5/2009 by formulating the following substantial questions of law, A1 and 2. From the above, two substantial questions of law so formulated, it transpires that the first substantial question of law pertains to as to whether the courts below were justified in decreeing the suit of the plaintiff without recording any finding as to whether the plaintiff's vendor had right, title, and interest over the land in question after promulgation of the Assam State Acquisition of Jamindari Act 1951. At this stage, it may be relevant herein to mention that the respondent numbers 1, 2, and 3 in their written statement have categorically stated that as per the revenue record, Sri Jyotish Chandra Das, son of Jugendra Chandra Das, and 6 others were the recorded owners. There was no written, though a written statement was filed by the appellants herein, but the same was not accepted. I've also perused the memo of appeal. In the said memo of appeal, there was also a memo of appeal before the first appellate court. In the said memo of appeal also, there is no grounds alleged, no grounds taken, no grounds of objection taken. As regards the extinguishment of the rights of the vendors of the plaintiff in view of the promulgation of the Assam State Acquisition of Jamindari Act 1951. It being a well-settled principle of law that for being a substantial question of law involved in the instant appeal, there has to be foundation laid down in the pleadings. In that view of the matter, as there is no foundation laid down in the pleadings or even in the memo of appeal before the first appellate court, it is the opinion of this court that the said substantial question of law so framed, formulated, is not a substantial question of law involved in the instant appeal. The second substantial question of law pertains to as to whether the suit of the plaintiffs for declaration of right, title, and interest without praying for consequential relief is maintainable. This substantial question of law has its foundation in foundation in the proviso to section 34 of the Specific Relief Act 1963. 63. This court finds it relevant at this stage to take note of the judgment of the Supreme Court in the case of Rukmabai versus Lala Lakshminarayan, reported in AIR 1960, SC 335. Wherein the parameteria provision under the Specific Relief Act 1877, being section 42, being proviso to section 42, was taken into consideration. It was observed by the Supreme Court in paragraph number 30. That it is a well-settled rule of practice not to dismiss suits automatically, but to allow the plaintiff to make necessary amendments if he seeks to do so. In the same case before the Supreme Court, the appellants who were the defendants in the suit did not take the plea in the written statement, nor there was any issue in respect thereof. The said issue as regards the proviso to section 42 of the Specific Relief Act 1877 was raised before the High Court the High Court had rejected the said contention. When the matter was carried to the Supreme Court observed in paragraph number 30 that a question pertaining to the proviso to section 42, which is parameter to the proviso to section 34 of the Specific Relief Act 1963, should have been raised at the earliest point of time, in which event the plaintiff could have been asked for necessary amendment to comply with the provisions of section 42 of the Relief Act. And as such, the said plea was not allowed to be raised. Paragraph number 30 of the said judgment is reproduced hereunder. This court further finds it relevant to take note of the relief sought for in the instant suit, wherein the declaration of right, title, and interest was sought for, along with confirmation of possession, which would also come within the ambit of the further relief. Within the meaning, it come within the ambit of further relief, within the ambit of the proviso to section 34 of the Specific Relief Act. In that view of the matter, this court is of the opinion that the second substantial question of law so formulated is not a substantial question of law involved in the instant appeal. Mr. Dhar, the learned counsel, appearing on behalf of the appellants, further submitted that two other substantial questions of law arises in the instant appeal. That is, Mr. P.K. Roy, the learned senior counsel, appearing on behalf of the respondent numbers 1 to 5, after due taking notice of the said substantial questions of law so suggested, have also made his submissions. In the backdrop of the above, let this court therefore take into consideration as to whether these two substantial questions, above quoted two substantial questions of law, further arises apart from the questions of law, substantial questions of law, which was framed by the order dated 29/5/2009. The additional substantial question of law, number 1, pertains to as to whether the judgment and decree passed by the learned trial court, passed by the courts below, whether the learned courts below were justified in decreeing the suit of the plaintiffs without discussing the evidence of PW1 and PW2 and ignoring Exhibit E in the case record. Accordingly, without any proof of title of the vendor of the respondent plaintiffs over the suit land, are perverse and unsustainable in law. From a perusal of the judgment of the trial court, while deciding the issue number 3, as well as the judgment of the first appellate court, while deciding first appellate, it transpires that the evidence of the PW1 and 2 were duly taken note of. At the cost of repetition, it is further stated herein, it is reiterated herein, that the appellant's herein did not file any written statement, thereby countering that the vendors of the plaintiff did not have right, title, and interest over the suit land. The defendant numbers 1, 2, and 3, who are the respondent numbers 6, 7, and 8, had also admitted in their written statement the ownership of the vendors of the plaintiffs. Exhibit E, the reference to which the learned counsel appearing on behalf of the appellant has made, is an order passed by the settlement officer holding that the plaintiffs did not have title over the portion of the land. Taking into account that the settlement officer is a revenue authority, in the opinion of this court, the said settlement officer, such observations and findings of the said settlement officer has to be restricted to only for the purpose of conferring of mutation and not for declaration of right, title, and interest, which is exclusively reserved for civil courts to decide. In the instant case, the civil courts have determined and decided that it is the plaintiff who have the right, title, and interest over the scheduled lands. And the said determination, in the opinion of this court, would overshadow Exhibit E. Under such circumstances, this court is of the opinion that the additional substantial question of law so suggested during the course of the hearing is not a substantial question of law involved in the instant appeal.
May I take review? I will.
The second additional substantial question of law relates to the non-filing of the written statement, not that the courts below did not permit, that the learned trial court did not accept the written statement filed by the appellant. This court, upon perusal of the memo of appeal, wherein various grounds of objection were taken before the first appellate court, the said ground that it reveals that there was no grounds of objection taken against the order passed rejecting the written statement before the first appellate court, which the appellants were at liberty to do so in terms with section 105 of the code. Under such circumstances, this court is therefore of the opinion that the said additional substantial question of law so suggested is also not a substantial question of law involved in the instant appeal. In that view of the matter, as the instant appeal is devoid of any substantial questions of law, the instant appeal, the same, the instant appeal stands dismissed. Prepare the LCR, return the LCR, prepare the decree, return the LCR.
Upright.
Next file video.
Item 13.
I can't take up. This matter has not yet been disposed of. My goodness. Before any other.
It will be after vacation.
I can't say anything. It won't be proper.
Item 40.
Yes, Mr. John, Mr.
My lord, last occasion also nobody appeared on 25.
Tell me.
My lord, concurrent finding, my lord, issue number 5 is the important, my lord. Right title interest. My lord, here question involved, my lord, is a grandfather of this respondent, my lord, gifted the schedule and my
Issue
lord.
number 3. Issue number 5.
Issue
Whether
number
the plaintiff has right title and interest over the plan.
Yes, ma'am.
How is the issue number 5 decided by the first appellate court or district judge?
Yes, ma'am.
Let us see issue number 5.
Page 13.
The winner has stated that the plan measuring Let us see his written statement.
Yes, my lord. Page 41. The ground taken that, my lord, is a defendant's predecessor, my lord, exchange the land verbally.
So at page 42, is this a translated copy?
It appears, my lord.
Yes. Now kindly read this particular page 42. Kindly come to page 2. The main patadar of the suit land. Have you got it? Number third
Yes,
paragraph.
yes, yes.
Transferred the suit land to late Ranjit Borua. Who is late? Who is
Ranjit
late
Borua
Ranjit?
is the father, my father.
Huh?
My father.
It can't be. Where is the deed of sale?
Nothing, no document exhibited.
No. He said that he is transferred by the deed dated, registered deed of gift dated, number
Yes.
1987. No, record to
But my
the,
lord, nothing, my lord, exhibited.
hey, record to the. Now, what is exhibit 3? Let's see.
Exhibit 3 is my document.
That is what? That is the main document.
Gift
No?
document, yes, gift.
Suit of 2006.
Yes.
Now, when is the suit of?
Suit of, my lord, 97. 1997.
Exhibit 3. This deed number is what?
Deed number, my lord, 1987. And serial number 2047.
Dated
Dated, my lord, 11.
yeah, 10 to 1969.
Yes, 69, yes.
About, what is the name of the plaintiff?
Let the, my lord, Bimal Chandra Bora.
This has been given by Adiram
Yes. Adira, my lord, my grandfather.
Potiya. Potiza. What is this?
Patia, my lord.
Huh?
Patia.
Khotia.
Yes.
What is this Khotia business? His name?
Bharat, my lord, they are Lalung people.
Hmm?
Lalung people.
And he became Bora.
Bora, somebody right, Bordoloi, Bora.
So this document has not been challenged. That is
No,
why relevant is
not challenge, my lord.
no,
even not
what they have
objected.
put it out there in their written statement seems to be something wrong.
And
When
my
we
lord,
come to the written
no
statement,
objection even
so
put, my lord.
parties- so it- Kindly see page 45.
My lord, in my memo, page 45 is not there. Perhaps it is my lord estimates.
You have a copy of the written statement?
That is translated copy. Yes, my lord, translated copy.
Now, do you have the original?
Translated.
Don't you have a copy of the memo, the written statement with you?
My lord, written statement, lord, translated copy, my lord, as they supplied me.
Here they do admit উক্ত বাদীর মাটি মূল পট্টাদার
Adiram Patia.
বাদীর দেউতাক মৃত রঞ্জিত বরা So their basic case is that this land was transferred by the grandfather by way of a gift to the father of the plaintiff. But
My
this is
lord-
a wrong thing because
My lord, they also in paragraph 5, page, my lord, 41, they says, my lord, that they are, my lord, exchange of property.
understood. That is why they say that the father of the plaintiff had exchanged
Grandfather.
father.
Father.
Father exchanged it.
Ranjit
That is why this.
Ranjit Durga, yes.
But the thing is, none is appearing out here. How can I
None
enter?
appearing, my lord, no document, my lord, they have exhibited, my lord. Even my gift did not objected, my lord.
Hmm?
Not objected. And last occasion, my lord, while the case was listed, quote on 25, 5, my lord, 23. My lord, observation, kindly see my last order.
Okay. None appears on behalf of the appellant on call. Mr. S. Chauhan, the learned counsel, has appeared on behalf of the respondent.
One.
Respondent. It may be relevant herein to mention that in the morning, during the mentioning hour, the appellant, some counsel appearing on behalf of the appellant, has sought for an adjournment. And this court, taking into account that the instant appeal was for the period of the year 2012, had declined to grant adjournment. When the matter has been called today, none has appeared on behalf to call up for hearing. None, the appellant is not represented, whereas the respondent is represented. Considering the above, this court, it appears before this court, considering this above, this court therefore dismisses the instant appeal for default.
My lord, one observation, my lord. Last occasion also, my lord, order is there,
Continue.
did not appear.
It further appears also that on 25/5/2023, none has appeared on behalf of the appellant.
M50.
Item? Yes.
Hello. The issue, my lord, that has been, my lord, reduced as a substantial question here in my lord revolves around section 65 and 63 of the Indian Evidence Act.
Whether the sale deed relied upon by the defendant, the original of which is lost, is proved under the provisions of section 65C, read with section 63(5) of the Indian Evidence. Yes.
Here is a case where basically the plaintiff says,
You are a plaintiff.
no, I was the defendant. The defendant is in possession of a particular plot of land. It will be land in the suit, which is in our possession since 1972. It is in the name of a club, Chhatra Keshri Ganga. the secretary and the members are otherwise considered as a defendant. We say that, my lord, this particular land was purchased by us in 1972 through a registered sale deed, and since then we have been under possession,
You have purchased it
my lord,
by the deed of sale.
deed of sale. My lord, that
Now what has happened? The original
the
deed of,
original was not with us, my lord.
so
We-
you filed some
we-
application.
My lord, the sub-registry say, and they also deposed as DW say, that that particular volume is not traceable in their office.
Then what did you do?
My lord, then we filed a writ petition. There is a direction from this court to the lower Assam commissioner to make an inquiry. The inquiry found out that that particular volume, my lord, while it was being transferred from Kamrup to then created Borpeta district, some volumes were missing and this is also missing.
Then
Then, my lord, I neither have the original as of now, neither a certified copy, my lord.
Then-
Because even the record is missing as of.
then
But then we say that the index showing our registration is there. My lord. That index, that particular index book, that the sub-register has certified and deposed also in the trial, my lord. That particular record is available. However, the exact date and that particular volume is not available.
no, where is the sale deed? Means whether the contents of the sale deed were available at any point of time.
My lord, the contents, a photocopy of the same was available, my lord. Exhibit 4, the exhibit 4 is the photocopy, my lord, that was available. But then the learned trial court and the appellate court both held that since we could not discharge our burden of proving our title by exhibiting the proper original document, the contention raised by us.
So your basic case is that as it was lost, the photocopy should have been taken into account.
My lord, plus the oral account of that particular transaction, which the DW1 had stated.
Who is DW1?
DW1 is the secretary, my lord. He has the secretary of that particular Sangha.
Who sold the land to you?
The mother of the defendant, my lord. Sorry, the mother of the plaintiff. One Geni Vitava.
Let's see how the court has taken.
Two particular paragraphs, Lord, see that the trial court at page 31 is
Page?
just finding. Page 31 is the finding, my lord,
Of the
of the trial court. That is the learned Munsif. Page 31 of the memo of appeal. This is the type copy, para 13. I have also perused the relevant documents exhibited by the plaintiff. to
page
substantiate their claim.
31, para 13.
13. I have
No,
also
before
perused
that, let us go how the evidence has been taken. Issue we are concerned is whether the plaintiff is entitled to get confirmation where right title interest. So there is no counterclaim by you.
no counterclaim, but we say that we are in possession. So in fact, there is no degree for
And,
recovery of
and the
possession.
plaintiff claims on the basis that the mother did not sell.
Did not sell.
Your case is that you have the mother sold it to you. Did the mother have the title?
She was a riot at that particular moment.
Then how could she sell it to you?
Yes, my lord.
She was a riot, admitted.
It is not my lord, mother, it is grandmother. My lord.
The grandmother, how can the
It is
grandmother
government
sell it
land,
to
my
you?
lord, cannot execute any registered sale deed.
Why did you file all the proceedings? Let's see how does the court deal with it. And how did you get the title?
My lord, my grandmother was the riot, my
Right.
lord.
Then
Subsequently, after the Zamindari system abolition, the possessor get the right as a possessor, my lord.
how?
My lord,
When was the right declared?
my lord, the
Zamindari system happened in 1951.
yes, my lord. Subsequently, ceiling surplus land.
So it is under ceiling surplus.
Yes, my lord.
Fixation of 56.
56.
Then there has to be a settlement made.
Paid for settlement.
Then,
my lord, during pendency of that settlement, the dispute arising.
then when did you get the title?
As per my lord record, the settlement application till today is pending.
So as of now, you also don't have right.
My lord,
He also doesn't have right.
We have possessory
but
rights
we
maybe
are in
from
possession.
72 onward.
We are in possession, my lord.
Then why have you filed the suit? If he is not disturbing you.
Disturbing, my lord. That is why I shoot.
But why, how did the court declare right title and interest in your favor?
As because
If
my
you
lord,
don't have title,
settlement
was the
application,
state made a party?
that is not my lord.
Then it is something like yesterday's matter which I saw it. A person is asking for a right title interest that saying that he is the only person who is entitled to receive the compensation. And there is a suit filed that this compensation should not be paid to him. I was trying to explain it to him. Look here, your suit is otherwise not maintainable. You have to go before the deputy commissioner or somebody for making a reference. Apportionment will happen in that manner. Plaintiff and defendant, so many.
We have to contest because we are in possession and there is some clubhouse and social activity going on.
Was
that
originally
particular land.
standing in it also Zamindar of the land, including other land of two under the state, but the grandmother was the recorded occupancy Katiyan Bennett, who enjoyed the land with heritable and transfer rights. Where did you have a Katiyan?
My lord. My lord.
Katiyan was given
Yes,
to you?
my lord.
Okay, then you have something. Was to pay the rent only, and in the meantime, the state levy it's Sarkari, who is Tonkeshwar Deka?
Tonkeshwar Deka is the father, my lord.
Huh?
Father of the plaintiff, my lord.
During the lifetime of these brothers, the possessory right and title of the stated land, while other portion of the ancestral land property was conferred upon his brother Upenda at birth. After the death of Tonkeshwar Deka, stated land was to be affected by Now, what did they sell it to you?
Hello. 1 bigger out of that particular plot of
What land?
that's
She was a riot.
the righty land only.
Can a riotee transfer the land?
No.
You know, the substantial question of law goes there. Why should I go into other?
But then by virtue of that date we got into possession and we have been enjoying
Whatever may
since
be,
1972.
whatever may be, if you are in possession, the finding of fact has been arrived at. But the question is that the only substantial question of law is that. And that substantial question does not have no bearing out there. Because if a riotee cannot transfer, what is this sale deed business? Think about, I'm coming in 5 minutes.
There's a conflict.
Mr. B. Pathak, the learned counsel appearing on behalf of the appellant. Mr. K.U. Ahmed appears on behalf of the school respondent. This court, by an order dated 4/3/2022, had admitted the instant appeal by formulating the following substantial question of law. It order to try the This court had put a specific query upon the learned counsel appearing on behalf of the appellant as to whether the executant of the sale deed, which was exhibited as Exhibit 4, had a transferable right to transfer the land to the appellant. The learned counsel appearing on behalf of the appellant with due fairness had submitted that the executant of the sale deed exhibited as Exhibit 4 did not have a transferable right. In that view of the matter, the said substantial question of law so framed is not a substantial question of law involved in the instant appeal. Accordingly, the appeal stands dismissed.
Item 16.
My lord, this is against the reduced tribunal. My claim was dismissed, my lord, rejected. My lord, basically on the ground that the ticket which was recovered, my lord, the ticket, the journey ticket, my lord, which was recovered, my lord, learned tribunal found some discrepancy, my lord. And accordingly came into conclusion that he is not a bona fide passenger. But my lord, last time I can see the order of the tribunal, my lord, page 32.
Right?
Page 32.
Yes. Which portion you are referring to?
That you will find. My lord, from 35. Paragraph 7, my lord. May I read, my lord?
Yes.
Let me kindly see one document, my lord, the page 22. This is the, my lord, the report of the, my lord, the police,
Page.
page 22, man.
Hmm. Yes.
Senior Police Inspector, Hasi Railway Police Station. Report. Humble request from AM Science Police Hall 1263 duty at Hasi Railway Police Station.
Page 22, Annexure 5.
Annexure 5.
What is this? This is by one CK Sable.
Yes, my lord.
Who is he?
He is, my lord, the senior police. He has.
No, he's an advocate.
No, my lord, he's written to the senior police inspector.
That is okay. But what does he say out here? Kindly see what he has stated out here in paragraph number 6 of the written judgment. The matter being serious, the above was initially filed with RCT Mumbai, and almost at the same time another case was filed for the same incident at Guwahati bench.
Right.
Now this is at Guwahati bench or Mumbai?
My lord, initially case was filed in the Mumbai, my lord, and due to some communication gap, my lord, it was filed again, my lord, in Guwahati, my lord. Thereafter, Guwahati tribunal called the record, my lord, and after that, the Guwahati bench, my lord.
Now see, during the course of the proceeding, this court got highlighted and taking cognizance of the matter, the case filed by RCT was dismissed on account of duplicate filing. The matter being serious was taken up by summoning CK Saule on behalf of the applicant, representing the case at RCT so and so to ascertain how double filing in this case took place. He, quoting medical reasons, pleaded his exemption from the court but sent an application dated wherein he stated that the application number so and so, filed by the same applicant so and so, the maternal by so and so, the maternal uncle of the deceased, and accordingly to the advocate was looking after the victim, it was he who had provided them with the railway ticket with an identity card so and so of the signature of the applicant. When the same thing was questioned to the applicant, he in his statement stated that his son was staying near to his maternal uncle's place and he was one who advised him about the death of his son in the train accident. He stated that after the last ride of his son, his mother-in-law took him some papers to enter. Then what is to be believed with this particular person writing out there? Anything else?
My lord, thereafter, my lord, the railway tribunal Guwahati, my lord, gone into merit of the case, my lord. Merit of the case, my lord. And I decided it on merit, my lord.
On the basis of a false ticket?
Yes, my lord, as per.
What do you say? The ticket, the name, the number is different. The not only the number, the photo which was pasted on the iCard was pasted later on.
But
what do you say that the name mentioned in the season ticket? No, there was no mention in the season ticket, the name, but in the iCard there was a mention of one Mugdar, whereas the name of the deceased is Muzakir.
Muzakir Hussain Lashkar, actual name, my lord. But Lordship may kindly see the inquest report, my lord, which was the prime report, my lord, for the accident, my lord. Page 24, my lord.
The inquest report also does not include that aspect of the matter?
No, my lord, there is a mention of the ticket, my lord. Don't know, number is there, my lord, but there is a mention, my lord.
What does it say?
Lordship, while last two paragraph, my lord, while taking search of deceased dress, one black color wallet is found in pant pocket, identity card, name Muzakir Hussain Lashkar, and photo rupees 40, case developer to Bhasi, second class railway pass. Papers, bond diary is found. Except these articles, nothing is received near him. So this is the report, my lord, inquest report, my lord.
No, but the court holds it different, no?
My
The
lord,
contention of the applicant counsel that there is a mention of railway ticket with railway I-card in the inquest report also is factually incorrect, as there is only a mention of the same in the inquest report with no detail of ticket number and I-card number, etc., to link it with the victim.
But the railway, my lord, did not examine any one of the my lord, the authority who is the my ticket. But it is the burden on the my lord railway to prove that aspect, because my lord, from the record and the application filed by the applicant on affidavit, the this applicant has discharged his burden. Ma'am. Thereafter, only the railway has to prove, my lord, burden shifted to them, my lord, as per my lord, the judgment of the Honorable Supreme Court also, my lord. In this case, my lord, my lord, admittedly ticket was found, my lord, and accident also, my lord,
What
admitted.
ticket was found?
My lord,
What was the number of the ticket found?
my lord, it is, my lord, that's a
What is the number of the ticket found?
my lord, in the inquest it is not mentioned, my lord. But
Then,
the ticket, there is a number, my lord. I have checked the record, my lord.
okay, what was the number of the ticket?
The ticket number was, my lord,
41.
1241, and the identity card attached
Yes.
to it, the number was 1242. That also doesn't match.
well, season or railway ticket bearing number 62971241, 62971242, issued dated 25/10/2014, valid
Very
from
good.
25/10/2042.
Season ticket.
Yes,
Season
ma'am.
ticket is above, the photo is above, so that is right. Now this is season ticket number 1242.
My lord, full is
Monthly ticket.
62971241.
Season I-card number, season adult season ticket number is, so I-card number is 1242.
Yes.
Season ticket number is 1241. How is it possible?
But the my lord,
And in you see here,
Lord.
ID number is very relevant. Well, which ID is referring to? Mr.
My lord,
Sharma, here it says season I-card 1242, ID number 94NIB3Q872. What is this? Name
Mutkar,
Mutkar.
Mutkar. Even,
Mutkar.
even the name doesn't tell you.
my lord, that may be, my
Holder,
lord.
no signature.
Okay.
Age 20 years. This was given in 2014. And this is what? Season ticket.
Season ticket, my lord. My lord, he was
How do you connect this season ticket to this with the I-card?
With the numbers, my lord. The number has to tally. Last four numbers, 1241. If the season ticket bears the number 1241, then the identity proof also would bear the same number, my lord, 1241. Yeah, both the numbers are different.
You are reading from?
The judgment, page 35 of the judgment.
That I have seen. 1, 2.
The only
And here there is a reference to two number 94N1B3Q871. You see this? The number of ID in the season ticket, season I-card is 94N1B3Q872. And in the next season ticket, it is 94NIB3Q871.
My lord, it can be only my lord, railway authority who issued the ticket, but that person was not actually.
Not necessary, but this ticket is clear, na?
My lord,
This ticket is clear. Does the I-card have to have the same number with this? Answer me that question. Where is the I-card rules? This season ticket, under what provision it is given?
pertaining to the Mumbai local, my lord. So,
How is it given? And why it was filed here?
it was transferred.
Well, this person is a resident of Hailakandi, my lord. This is residing here, but he went there for my lord security guard. An accident happened there, my lord. From the other record, my lord, also report, inquest report, my lord, police report, my lord. So he's admitted, my lord, the accident is there, my lord.
We are all villagers came to Bhakti. Only railway park like our photo, my nephew was sick on my car. My nephew. But this eviction of the photo is done later on.
My lord, as per my instruction, my lord, they issue it, but this photo is pasted later. They simply issue this.
Show me there will how iCards are given. Show me somewhere something. Otherwise, how can I decide this? Yes, Mr. Sharma.
My lord, on the photo, my lord, in the iCard, there would be a stamp seal imprinted by the authorities, my lord. It's absolutely wrong to say that the photos are pasted later on, my lord. You submit the photographs and thereafter the railway authorities would issue.
Instruction at the time of issue, they provided like this.
No,
Later on, my
definitely
lord,
not.
it was
my lord.
pasted.
Definitely not.
But it was found, my lord. Admittedly, this was found within this disease, my lord, from the inquest report, my lord.
No, inquest report. These many things can happen, Mr. Counselor. This time not on this.
And from the page 22, my lord, is the report from.
I don't understand what is this ID number 94NIB3Q872. What is this ID number?
May I just
Yes, have a look because you see the next ID is different. Next number is 871. There must be something important, relevant. Mr. Counsel, if you can't satisfy both of you, what to do?
My lord,
How iCards are issued? You have to show it to me. Then only I can hold it. Otherwise, I'll hold it. Yes, railway authorities knows it. I don't know much. These people deal with it every day.
this pertaining to Mumbai local, so maybe
that's why, my lord. When I discharge my pardon, my lord, the railway, my lord.
Burden of what? With a
Well,
ticket.
I have
With a
given the-
ticket,
yes,
which has a different number.
but it's the, my lord, tribunal, my lord, have a presumption, my lord.
I didn't do a presumption that see the ticket. You may not have seen it. Were you appearing before the tribunal?
I have seen, my lord. but-
Then you have seen it. You know it. You see, there is a number, ID number. You see it, Mr. Sharma?
yes, yes.
After 1241 on the top one, ID, then down below there is a number 94
For
something.
M1B, I got it, my lord.
One is ending with 872, other is ending with 871.
871. But on top, my lord, there are two numbers which are mentioned in the judgment, my lord. 1242 and 1241. my
No,
lord.
that is okay. Then thereafter you
This
see the
is
difference.
yes.
What is this ID business?
This is probably, my lord, the ID number, identity card number. And
No. It can't be an identity card number of what?
of the person concerned. And on top, my lord,
You see, why I'm saying is 1241
is it
has the last ending number as 871.
871? Yes, my lord.
1242 has the last ending number as 872.
872. My lord, in the ticket which with the number ends with 871, it's not ID number, it's UTS number, unreserved ticketing service, my lord. That is the ticket number, probably. UTS means unreserved ticketing service.
No, there are two numbers.
Two numbers, my lord. In the ticket, my lord, it's not referred to as ID. It's referred to as UTS number. And on or the, my lord, the ticket which is
So
on the
both
top
must have been issued almost simultaneously
simultaneously.
because 1241 has to proceed,
But-
precede 1242.
My lord, this ticket is, my lord, ex facie, not issued against the particular ID number, because both will have to tally. That
What is
the,
your basis to say?
well, that is the rule probably. That's why the judgment
No,
says so.
no.
I'll
Then
have to-
the rule probably can't be the thing taken for the purpose of non-suiting him. Na?
Even
Yeah.
otherwise, my lord, the name of the petitioner and the person on
I
ticket.
give you 4 weeks. Get your instructions.
My lord,
on this.
I
Heard, Mr.
Duty.
Appearing on behalf of the appellant, Mr. B. Sharma appears on behalf of the NF Railway. Upon perusal of the impugned judgment and order dated 3/1/2019, it reveals that the learned tribunal had rejected the application seeking compensation on the ground that the deceased was not a bona fide passenger. In doing so, the learned tribunal
another aspect.
had observed that the number of the season ticket was mentioned as 1241, whereas the identity proof was mentioned as 1242. It was further mentioned in the impugned judgment that the photograph which was pasted on the iCard was pasted subsequently as the same appeared to be over the stamp. This court finds it relevant that for the purpose of, this court is of the opinion that for the purpose of deciding the appeal, it would be relevant to know as to how the ID as well as the season tickets are issued by the railways, as has been railways. So this is Western,
Western Mumbai local, my lord, Western Railway.
by the railway, by the railways, by the railway authority. And also as to whether the photograph is pasted upon the iCard subsequent to issuance of the iCard. Mr. B. Sharma is granted 4 weeks' time for obtaining the instructions in that regard.
Can I have a photocopy of that? Mr. B. Sharma further submits that due to that, in order to obtain the instructions, he may be permitted to, he may be given a photocopy of the state season ticket and the iCard in question. The courtmaster is of this court is directed to give a photocopy of the said documents so that Mr. B. Sharma can obtain the necessary instructions in that regard. List the matter again on 27th July. For sustaining a claim for, my lord, compensation, two things have to be proved, my lord. Number one, that the victim was a bona fide passenger, and
That
number
is
two,
the main thing.
and number two, my lord, that the incident is an untoward incident within the definition prescribed in the
That will look into it, but the trial because that aspect Once this is clear, that aspect can be very well looked into by the tribunal.
On both counts, they failed.
Very well. We'll look in.
I'll certify.
Give him a photocopy of that.
Item 17.
Yes.
This appeal is preferred by the insurance company against the judgment of the learned tribunal, telling the order on the ground of the liability and quantum. They have challenged the liability because Your Lordship, after making an investigation by the insurance company, it found that the deceased was driving his own motorcycle. But the claim, it was the contention of the claimants that
You had an insurance company.
I got the insurance.
67 lakhs.
67 lakhs was awarded.
What was he working?
Your Lordship, he was owning a pharmacy, Your Lordship, in a partnership.
Huh?
Proprietor of a pharmacy
Huh.
in partnership with another person, Your Lordship.
What is the basis of arriving at such a huge amount? Monthly expense. What was his age?
His age at the time of his death was 34 years.
So what is your problem as regards the quantum?
Quantum, Your Lordship, because it was a proprietorship firm, Your Lordship, the pharmacy with a joint partnership. And after the death of the deceased, the shares is going to the claimant, that is the wife of the deceased. So in that regard, Your Lordship, there is no complete loss of earning, Your Lordship. The wife of the deceased was getting the part of the share which is earned by the pharmacy, Your Lordship. And it can be very well been could be find out from the LCR, Your Lordship, and it is deposed by the partner, one of the partner of the deceased.
And
This is the sole ground on the effect of the quantum, Your Lordship.
anything else?
Anything, Your Lordship, the liability we have challenged because the insurance company has made out an investigation by appointing an investigator, and upon carrying out the investigation, it is found that from a Facebook post, Your Lordship, posted by one of the friend of the deceased.
He was alive.
No, Lordship, because he was riding the motorcycle by himself, and suddenly a cow came in front of him, and he dashed to the side of the railing of the road, Your Lordship. And it was his own cause. For own cause, he had.
And after hitting out there, he had put a Facebook post.
No, Lordship, the friend of the deceased, Your Lordship.
Then did you adduce that in evidence?
Lordship,
And what did that trial court say?
Yes, because the person who had posted the said Facebook post was not cross-examined, was not examined. That's why the tribunal has not considered our evidence. Although we have the investigator was placed before the tribunal and was examined, but the person who have posted the Facebook post was never brought to the tribunal. On the part of the quantum, Your Lordship, because it is evident that the some of the part of the share which is earned by the pharmacy, it goes to the claimant, Your Lordship. In that regard, there was not complete loss of earning. Some person ought to have been deducted. Tribunal has taken monthly income as 32,000.
In one judgment recently, I saw it. That is a judgment pertaining to No, there is one judgment of a recent judgment. Yes, Mr. Doctor, this is a judgment I got. This was pertaining to some agricultural land.
That judgment it is of 2003, Your Lordship, just in agriculture
2000?
2003.
No. This is regarding agricultural land, and he used to get rent.
Well.
So the question involved therein was whether this income should be taken into account.
There are some decision in that line,
Huh?
but there are some decision in that line. But probably in this case, it is not necessary to go into. My learned friend has argued that, but your lordship will not find this thing in the evidence. Now, the lady who is there now, who is claiming, my lord, she is not in the pharmacy business. It has been abandoned, and there is nothing on record, my lord. Even the evidence will not show that she has the income from that pharmacy. My lord, where from my learned friend has made such statement, I do not. So therefore, your lordship, for the time being, for this case, it is not necessary. Otherwise,
Because there in that case, it was held that then also he will be entitled to the compensation. He will be entitled to maybe, but but there is also to look into all these aspects of the matter. Earlier he was looking into. Now they have to look into it. And as such, that person what he was looking for that compensation was given in 2023. Earlier. I've not been in touch with these matters for
for some time.
So I have not been keeping in there. But that day I gave it to my brother. He was reading it. But there is nothing on evidence.
No, nothing. There is nothing on evidence. So far, my lord, other part regarding that Facebook story, my lord, that is only pleading. There is no evidence at all. So, my lord, if your lordship has to come to, and the trial court has rightly come into finding that you have stated certain things in the pleading, but you did not give any evidence.
Show me that.
Your lordship will find that finding.
On the materials on record by the claimant clearly will that the delegate
Your lordship may come at page 17, my lord.
17.
17. Is the last few lines. The OP number 3 has not taken any steps to examine Dhiraj Kalita, maker of the Facebook post. No other eyewitness has also been examined by OP number 3. It is also not the case of the insurer that their investigator had intimated about the Facebook post to police. Facebook posts and updates are interpersonal communication between subscribers, members on the social media platform through their respective accounts. Unless the maker of such posts are examined before the tribunal court, no reliance can be placed upon it. The finding is very clear.
Now, how did you prove this Facebook post?
Your lordship, we have examined the investigator, your lordship.
Understood, but how? It's an electronic document. How did you prove it?
So that part was there was a lapse on that part. So for that reason, that he was not considered by the Thanet tribunal.
No. Forget about Dheeraj Kolita being a crime. How did you prove that the electronic evidence?
We have not obtained the certificate, Your Lordship.
Then since that certificate, can the Facebook post at all be considered? Forget about Dheeraj Kolita. If it is an electronic document, you don't require that that person needs to be examined. That is, I don't accept it. But you have to prove it in terms with 65B. Where is it? Isn't it?
Yes, yes,
You may not get Dheeraj Kolita.
right.
But if you want to prove that as an electronic document, it has to be done in the manner stipulated in the
Yes, in a systematic manner.
which says that it has to be on the basis of a 65B certificate. And I hope Indian Evidence Act applies.
Yes.
Then how did you prove that Facebook?
Only thing is the quantum part, Your Lordship, regarding the partnership deed, that can be found in page 20 of the LCR, Your Lordship.
Page
28 of the LCR. Your Lordship. Across, Your Lordship, the partner of the deceased, it has posed that the wife is
LCR.
getting the share.
Cross off?
Cross of page 28, Your Lordship. On the back
Who is
side,
he? Arup Padgiri?
he is the partner of the deceased, Your Lordship.
I, Arup Padgiri, I know Mittal. I'm the joint proprietor of Sun. Yeah. I have entered into a fresh deed of partnership with the deceased partner's wife, Anita. This was not taken into consideration. So that judgment becomes relevant.
My lord, he is not the partner. I have the specific instruction.
But this is the evidence.
My lord, it's by Arup Padgiri.
That is a partner who is your witness.
Well, the page 6 that I and late Nitul Medhi was joint proprietor of Master Shanti Drug Distributor. We have paid income tax for the income for the firm regularly. I have exhibited so and so. Onita Medhi is not the partner. Regarding Onita Medhi, that is not there, my lord, that she is the partner.
I
Nitul
have
Medhi,
entered into an pledge deed of a partnership with the deceased partner's wife, Anita Mit, last night.
my lord, this is the evidence of Arup Patgir.
Hmm. That judgment will be relevant for you.
After the death of my partner, I have applied for fresh license. The same is yet to be issued. To the tribunal, it has been said.
Who?
My lord, your lordship may see the cross part to the tribunal
By whom?
by this Arup Patgiri. He was cross-examined.
Where?
Uh, uh, that is the next page, my lord. The evidence in affidavit.
Have divided the profit earned by the firm in the ratio of 40.
Arup Patgiri, one oath your lordship will find. I am the joint proprietor of Shanti Drug Distributor along with this is Nitul Medhi. I am not sure whether the partnership duet between me and Nitul Medhi has been filed in the present case. Nitul Medhi and I divided the profit earned by the firm in the ratio of 50-50. The audit report of firm has been submitted by the claimant to show the distribution of profit between me and my deceased partner. I am not sure whether this is Nitul Medhi had filed any incomplete return individual. Then to tribunal. Shanti Drug Distributor was set up in the year July 2010. The license was valid till 11/7/2015. When my partner died, the process of renewal of the license was going on. After the death of my partner, I have applied for fresh license and the same is yet to be issued. I have entered into a fresh duet of partnership with his partner's wife, Monica Mehta. That license, according to me, is yet to be issued.
Where? I have applied for fresh license and the same is yet to be issued. Then see, I have
entered into a fresh duet of partnership with deceased partner's wife, Anita Methi. But if the license by that period of time was not yet issued, how he can carry on the business? Right? Partnership they might have entered, but the business didn't continue according to him. He has clarified. After the death of my partner, I have applied for the fresh license. The same is yet to be issued.
But he did not say that my business is closed down.
No, business he might be doing, my lord. His business is there. Okay.
But for that, he have entered into a fresh deed of agreement, partnership with the deceased.
But unless the license is issued, that cannot be carried on.
Where is that evidence?
My lord,
Where is that evidence?
my lord, this I'm just reading to the tribunal what he has said.
Understood, but then also you have entered into an agreement. What does she say? Was she cross-examined?
Yes, yes.
I have filed the documents of the permissive only the partnership by my husband and I have also filed the accounts of the permissive to show my income. In another country did not have any valid license on the day when the alleged accident. I have filed documents to show that my husband's age was he was 12. It is not a fact that the postmortem report submitted by the AI is not filed. The partnership of the AI executed by my husband today. It is not a fact that since my husband died due to his postmortem,
I have not filed the partnership duet of Shanti Drug Distributor executed by my husband with his partner. is not a fact that since my husband died due to his own fault by writing. And the fact she is denying, my lord. Therefore, my lord, there is no clear evidence to that effect.
There is no question put by you in the cross-examination.
To the wife. Or
Huh? Absolutely silent on that. We'll have it on next Thursday. Mr. Dutta. You'll get hold of the judgment.
I have placed the judgment before your lordship.
What judgment?
Your lordship, that is with regard to the deceased was holding a agricultural land and was having a milching farm, your lordship.
Land owner agricultural.
Understood, but this is a, I'm telling you, this is an old judgment. Law has changed on that. But Mr. H. Dokoma,
H. Buradhan.
right, Disciplinary counsel appearing on behalf of the appellate. As Dr. the learned senior counsel assisted by Mr. A. Manso appears on behalf of the response. Hearing is inclusive, leads to matter again on days for 26
As part of
of further hearing.
your lordship will mark as part.
So further hearing. Liberty given to the appellant, a respondent to the parties to mention the matter. You get hold of that. This is a very recent judgment.
Well,
I think it is a judgment by Justice Surya Kant. Nowadays, WhatsApp, what happens? I keep on giving. WhatsApp also these loses na after 7 days or 1 day or
Yes,
something. Yeah, I was trying to.
Justice Suryakant and Justice P.
Yeah. Eh? Just give me the petition and I remember that something. A Ramaya. A Ramaya. No. What's it?
National Insurance.
A dot Ramaya. You have the citation? It will be live law then.
I told you story.
Okay. This matter of fact, the deceased share of ownership in the business venture was transferred to the deceased minor children just before his death or to the dependents after is not a sufficient justification to conclude that the benefits of this business continue to accrue to the defendants. Entire amount under the income from house property and ER need not be deducted merely because the properties have been bequeathed to the defendant. Compensation towards loss of managerial skills can be awarded. These are aspects which needs to be. Dependents entitled compensation for loss of income if the business or properties of they were bequeathed to them. This is a judgment which will help you. We'll just give you the what is the Ramya. That is why I'm not getting it. Na? Okay. 2022 SCC online SC 1338. You got it? Yeah. Told you. I remember then.
Only in this case, the lordship will not find on record that she is really a partner in that business. There is nothing on record. But
No, in fact, they have not put that question also.
Yes, yes. In cross-examination, they did not put anything.
No,
Furthermore,
otherwise-
I'll
no.
try to get this instruction out.
You get your instruction, but anyways, there's no problem with that. Only thing is, I was 4:15. I don't feel like
Yes,
any. Today there has been a lot of matters.
Right.
I'll keep this. I'll dictate the judgment on your.
Well,
don't keep nowadays any partner. What do you call? PAV. Yes, Mr. Sahiwala, waiting for such a long time.
19
Must
and
be
20.
must be something very.
Wait, my lord.
Huh?
I have to wait, my lord. The
Which
last two
one?
items, 19 and 20.
Must be the matter. Must be some landlord eviction matter.
Yes, my lord.
Yeah.
Landlord, no.
You are the tenant.
It's fine.
Huh?
Big market area, my lord. In the market area, my lord, I have 5 shop actually gotten. These are the
We'll
two.
have it on some other day. Have it after vacation. Item number 19 and 20. The matter be listed after vacation.
My only prayer is, my lord, the item number 20 is yet to be admitted. Is it wrong? It is to come in the hearing column. May it come up in the admission column, my lord, along with the item CRP 8722 with.
No, what is this 87, 22 and 48? What are these two matters? Same matter.
No, my
It is
lord.
the same
actually,
landlord tenant. Same landlord tenant.
But
first
the
item-
matters are different.
matters are different, my lord.
Who's my lord? The shop.
No, no, tenants are
Tenants are
different.
also
Tenants
tenants are same, but the family members are different. Landlords are different, my lord, under the different
So both
first
are
title.
separate matters.
Yes, my lord. There
So
is no,
here the case LCR will be different.
yes, my lord. LCR will be different. Everything is different.
Okay, we do one thing. 19 list the matter after the summer vacation.
20, my lord. Can be,
20 we admit it call for the record.
Yes.
You are appearing.
My lord.
my lord, can it be after vacation an endeavor may be made, my lord, to dispose of at the admission stage? my lord?
Oh, we'll have it together, no?
Yes.
Okay, my lord. But my lord, in your lordship's order is there in 87.
Hmm?
Your lordship's order is there in
Rent
87.
has been enhanced, my lord.
In 87.
Rent has been enhanced and we are paying
Enhanced
the
in
enhanced.
87. But here the stay is there, but there's no.
No, we'll require the LCR, no? Without LCR,
Yes.
how can we dispose of?
No, I'm not asking for disposing, my lord. Only till the period of.
He's paying.
Yes,
No,
we are paying, my lord.
in one case
Oh,
only he's
these
paying, my lord.
Atmaram
There's-
properties.
Yes.
Ah,
That,
I've
we are,
increased it to 6,000, no?
my lord.
Yes, my lord, in 87, but in 48, there is no such order, my lord. So my only prayer is that that can be considered, my lord. Better may be
Directed
hard
to
after
either pay
vacation,
the
but in the
said amount
meantime,
as directed in the trial court on the next date.
he is
or
merely paying
so by
1,800
way of
rupees, my lord.
emphasis. So we'll do one thing. We'll admit this.
Yes.
Heard Mr. G.N. Sahiwala, the learned senior counsel, assisted by the Ms. S. Turi, and Mr. G. Jalan appears on behalf of the respondent.
Yes, my sole response.
Upon perusal of the materials on record, this court is of the opinion that this is a fit case for admission of the instant appeal, instant revision petition proceedings. Accordingly, the revision petition is admitted. Call for the records. The registry is directed to take steps in that regard. List the matter immediately on receipt of the records. So this is segregated with this 48.
Yes.
48 to it was a list the matter for hearing on 8th of August. That's it to Agor matter to do. This court further observes that the interim order passed earlier shall continue and the petitioner shall further be further directed to continue paying the amount as fixed by this court. You get the 6,000.
यार तेरा नहीं बचता है, खराब है। हाँ तो इंतजार है मैं कब उठेगा जल्दी वो आप फोन कर दीजिए अकाउंट है उसको बोलिए कोर्ट ऑफिसर कोर्ट मैनेजर से बोल दीजिए वो अपने ठीक करेगा उसका डेली काम है देखना है क्या करता है कहाँ आ गया इधर कोर्ट में हाँ?